Yes.
May I see, Lordship? I beg to mention the for withdrawal after tomorrow.
Yeah, please, Lord. Lord, I beg to mention item number 31, my lord, with the consent of the other side, Lord. No, let it be adjourned for 3 weeks, Lordship. We need to file our affidavit.
Okay. You as a standing counsel
Lordship.
for GST?
GST, man.
Okay. Mr. Setia, learned standing counsel, GST, has sought listing of the case after 3 weeks in order to file the counter affidavit in the meantime.
Lordship.
He has submitted that consent has been taken from the learned counsel for the petitioner to make the prayer. First up,
In order first condition.
the Mr. Borua, PK, P. Borua, learned counsel for the petitioner is present. The prayer is allowed. Prayer made by Mr. Setia is accepted. Leaves the case after 3 weeks. On date to be fixed by the office, the interim order passed earlier shall continue till the next listing.
Lordship, I have a similar prayer for item number 39. Same counsel, Lordship. Same, Lordship.
Okay. Interim order is there. Same then.
Deeply obliged.
Lordship, item number 38, Your Lordship.
38.
Yes, yes.
Yes.
We also need to file affidavit on behalf of GST, Your Lordship.
GST.
Yes, Lordship. With the consent of the other side also.
Okay. Dr. B.N. Gogol, huh? Same. Any interim order?
Yes, yes, sir. It is there.
No interim order. Mr. Your name? S.K. Saha for the petitioner present.
Diplomas.
Please, Lord. My Lord, item number 47, Lord.
47.
I have to file affidavit in this case.
47. Why it has come? Orders column?
Yes, Lordship. I have to file affidavit, Lordship, in this case.
Additional affidavit.
Lordship.
Okay.
Rejoinder as well as on service, Lordship.
No, 47.
47.
Some report was called for.
They have filed affidavit, Lordship.
Huh.
Filed
Rejoinder.
Lordship.
Okay.
And service on affidavit on service also, Lordship.
Okay. Mr. M.I. Hussain, learned counsel for the petitioner, has sought for listing of the case after how much? 2 weeks. In order to file a rejoinder affidavit and an affidavit as regards service of Dusty. Upon the response number 5 and 6.
Lordship.
It is submitted that consent has been taken from the learned counsel board of other parties to make the prayers, release the case accordingly. After 2 weeks on date, we fix all that.
Lordship, item number 25, Lordship.
25.
You know, sorry, Lordship, this is a long matter and it will take a long time. So may I pray that this matter may be fixed on a hearing date, Lordship, as per your Lordship's convenience.
This is some virtual prayer for virtual.
Yes, Your Honor. Because the learned ASGI was also to appear in this matter.
Yes.
Now, the thing is, it is going to take some time. And my instructions are to press for a expeditious disposal of this matter.
Okay.
So,
During what time? This month?
Your Honor, we're looking at the 28th. And if Your Honor,
28th of May.
yes, Your Honor. And if it may be possible to list it at 2 p.m. so that it can be disposed of.
Okay, we'll post it. We'll take up at 2. Okay. Mr. P.K. Borua, P. Borua, learned counsel for the petition, and Mr. D. Das,
Please, Your Honor.
learned standing counsel, CCI,
Lordship, I am for respondent number 4.
and Mr.
B. Chaudhary, my lord, respondent number 4.
B. Chaudhary, learned counsel for the respondent 4. I made a joint prayer to release the case on 28th of May, 2026. With the submission that the exchange of pleading is complete.
Lordship.
full stop. Raise the case accordingly on 28th of May 2026. Okay, you make a mention on 28th, we'll take up at 2.
Pleasure.
May I please, your lordship? Lordship, item number 19, your lordship. On
19?
motion, your lordship.
Yes.
Mr. Ganguly has some difficulty to do, your lordship. After a week, if possible.
Okay, on the request of Mr.
Three Chetri, your lordship.
T. Chetri, learning counsel for the petition, raise the case on a date in the next week.
Much of it.
May it please your lordship. Lordship, I beg to mention item number 3, my lord. Lord, in this matter, my lord, one outstate counsel, Mr. A. Chakraborty, he is appearing in the matter, my lord. So he is not able to present today. My lord, can it be fixed on my lord 25? I have already informed the other side, my
On
lord.
which date you want?
My lord, 25th of this month.
25th of this month. Okay, on the care of Mr.
K. Boyso, my lord.
K. Bosundra, learning counsel for the petition, raise the case on 25.
My lord.
5. You have informed the other side.
Yes, ma'am.
Lordship,
Okay,
I'm
Miss
N Kakoti Lordship,
N. Kakuri, learning counsel on behalf of,
GST Lordship,
who is the GST standing counsel?
Senior Advocate SCK Lordship.
On behalf of Mr. S.C. Kyle, the learned standing counsel, GST. Is present.
My
Item number 3.
May I please, Mr. for listing the unlisted matter today, Lordship, regarding demolition or removal of a Patka house of the petitioner, Lordship.
Patta?
Patka house, Lordship, where.
Patta house on which land? Own land or somebody else's
No,
land?
Lease land, Lordship.
Huh?
Respondent authority given a lease is a bit
Why
to the
today?
market area for construction a house.
Why
Lordship.
today?
Today, Lordship, they have issued a impugned order on last 27 to demolish within a 7 days, or they will, after 7 days, they will.
27.
27, they have.
7 days is over.
No, Lordship, today is last.
Tomorrow,
day.
huh?
I have filed on 2nd May, Lordship, this case, Lordship. Today is the last day, Lordship,
Today is the last day for
Last day.
expiry.
for removal of the, or demolition of the house.
Okay, let us try.
I have already filed. Obliged.
Please, Lordship. I beg to mention item number 41, Lordship. Infractions, Lordship.
Mr.
And Borwell, Lordship.
N. Borua, learned counsel for the petitioners, has submitted that the writ petition has become infructuous. Subject matter of the writ petition has become infructuous. Mr. Okay. Ms. M. Borman, learned junior government advocate for the state respondent is present. In view of the submission made by Mr. Borua, learned counsel for the petitioners, the writ petition being infructuous, is dismissed.
May I please, your Lordship? Lordship, I may be allowed to move an unlisted motion today.
Why? What subject matter?
Lordship, pursuant to an incident of 14-4, Lordship, Sipazar police station without established procedure of law, harassing me and charging me, Lordship.
Huh?
Sipazar police repeatedly charging me without following the established procedure of law, without registering their case, Lordship. So, Lordship, mandatory period of 14 days inquiry is also over. No notice under section 35 is issued, Lordship, till date. I am taking.
Why writ petition?
Lordship, because my fundamental right to file a bail petition has been violated, Lordship. No police case has been registered. I went to the prosecution inspector office. Police has not registered the case.
Even on apprehension, anticipated bail can be moved.
Lordship, but without.
Even on appreciation, apprehension, anticipated bail can be moved. Why writ petition?
Lordship, I have annexed a similar order, Lordship, passed by your Lordship recently. Similar order I have annexed, Lordship.
On what apprehension?
Lordship, repeatedly police calling me to the police station, Lordship.
Yes, an anticipated bail can be moved.
That's correct, Lordship. But
Yes,
in the writ petition,
the
Lordship,
Supreme Court
Lordship has
says
given indulgence, Lordship, on earlier occasion, on last 16-3, Lordship. I have annexed the order, Lordship. I am paying for a similar order, Lordship.
otherwise if I find, I will dismiss it.
Lordship, Lordship,
Right there
Lordship,
in limine
Lordship. Today, Lordship,
tomorrow.
Lordship, much obliged.
Wait, please, Your Lordship, I beg to mention for listing of.
When it was lodged, FIR,
14-4, Lordship.
day after tomorrow, no matter.
Your Lordship, I beg to mention for listing of one writ petition civil for admission. So kindly a short date may be given, my lord.
Give it to the court master.
May I please, Your Lordship? May I please, Your Lordship? To the concern of the other side, I beg to mention item number 5, Your Lordship. Kindly the matter may be taken up on Friday, Your Lordship.
Friday,
Yes, Your Lordship.
not Friday, Monday.
Lordship.
Okay, on the request of Mr. S.K. Saha,
Yes, Your Lordship.
learned counsel for the petition and raised the case on Monday. It is
11th.
submitted that consent has been taken. Huh? Look at you. 5.
My pleasure, Lordship. I am praying for listing a writ petition 1/7, Lordship. There is some urgency, Lordship. Matter is regarding to eviction, Lordship. The respondent authority has issued a letter for the eviction, Lordship. Kindly 1/7, Lordship.
When it was issued?
Lordship.
Have you filed?
Yes, Lordship. I have filed, Lordship. Filed on, Lordship.
Wednesday.
30. Wednesday, Lordship. Obliged.
Prayer for listing, Lordship, on date petition.
Admission column.
Admission column, Lordship.
Give it to the court master. What is your subject matter?
Cooperative society, Lordship, the matter was pending because rate appeal was going on. Rate appeal is already disposed of, Lordship.
Okay, give it to the court master.
Similar prayer, Lordship, prayer for listing of one deed petition, Lordship. Prayer for listing of one deed petition, Lordship.
In what column? Motion column?
Admission, Lordship.
Admission. Okay, give it to the court master. What is the subject matter?
Lordship, this matter pertains to discrepancy in population mapping of a village, Lordship, after delimitation.
Delimitation.
Lordship. Lordship, we are not challenging the delimitation, but we are challenging the discrepancy in the population mapping of that particular village, Lordship.
Okay, give it to the court master.
My pleasure, Lordship. Lordship, I beg to mention for the listing of writ petition 1475 public 2025. The matter is about the allocation of patta land, Your Lordship. The land of the
Okay,
petition.
hand it over to the court master. Admission column. Admission.
For orders.
Okay.
May I please, Your Lordship? Lordship, I beg to mention a IO for which was for implement. Lordship, it was last listed on 25/3
Okay.
for orders.
Court master will give a date in the next week.
Yes, Lordship.
Daily list for motion, item 1.
Is aggrieved, my lord.
Bring the mic to.
My lord. Is aggrieved at the inadequate compensation, my lord, against their land possessed by the district collector, my lord, Borpeta, my lord, for the construction of railway over bridge, my lord. Yeah, my lord.
Petitioner.
Yes, my lord.
He is the owner of the land.
Yes, my lord. Co-partner, my lord, of a land, my lord, measuring 3 kata 13 lesa in the Shorbok town, my lord. Now, my lord, the district collector, my lord, while issuing the notice, my lord, for acquisition, my lord, they fixed the value at rupees 45 lakhs per bigha, my lord. Whereas, my lord, the circle officer, my lord, in earlier occasion, my lord, had fixed the value of 1 crore 30 lakhs per bigha.
Circle officer? Where is that?
My lord, page 27, my lord. Yeah, my lord, kindly come to my lord.
What is the date of this letter?
My lord, date is.
Any date? No date.
No date, my lord.
No date.
No, my lord. My lord,
Now,
it
what
was-
is your
it
fixation? What is your amount fixed?
My lord, my amount, my lord, they have fixed, my lord, at the rate of rupees 45 lakhs, my lord.
No, where from we can gather that your land is being taken away?
My lord, page 24, my lord, you should find they have fixed the valuation, my lord.
No, where, okay, this concern.
My lord, I have annexed page 20, my lord.
Page 20.
Yes, my
all
lord.
concerned
21, my lord, is the
are
relevant portion, my lord.
informed that as per regulation. Which is your land?
My lord, page 21, my lord, you should find, my
20, 20,
21,
20, 20, some lands are mentioned here.
Yeah.
Which one?
my lord, thermal 21, my lord,
Page 20.
20, yes. This is the, my lord, the name of the area, my lord. Page
No,
20.
area of proposed land.
Yes, my lord. This is the
Right.
Yes.
There
Shorbok
are
town.
patta lands and few government lands.
Yes, ma'am.
Right.
Yes,
Out
ma'am.
of patta lands,
Yes.
total 6 bigha, 2 katha, 2 lesa.
Yes.
And there are three patta lands.
Yes.
Which one is yours?
Shorbok town, my lord.
Right. There are 3 patta lands.
Yes. ma'am.
One is 3 bigha, 15 lesa.
Yes,
One is 1 bigha, 3 lesa.
Out of this 3 bigha, my lord, petitioner's land for, my lord. And kindly come.
Have you received any notice?
My lord, they have issued only as a whole, my lord. Not individual notice was published, my lord. I have quoted the relevant portion, page 21, my lord. Your lordship will find, my lord.
That is your land.
Yes, my lord.
What is the original law? This one.
My lord, originally not so visible, my lord. Page
Where is
23,
that?
23, my lord. It is merely visible, my lord. Not readable, my lord.
Page 24.
My lord. They have
Which one? Which
they have
one?
fixed the value, my lord. The second class commercial land, my lord.
Second class commercial. 45.
They have fixed the value at 45 lakhs, my lord.
45
Lakhs, my lord, per bigha.
lakhs. Any compensation amount is fixed?
Yes, my lord. They have fixed, my lord. Lordship will find at page 25, my lord.
17 lesser.
Yes, my lord. Out of
Your
yes, my lord. 17 lesser, so my
for that 20 lakh 27,250
yes,
has been fixed.
yes, my lord.
Now, is there this is a direct purchase system, Miss Bormon?
Lordship, I have got some award copy, my lord.
Let us have. Whether he has consented. If consent is there, then Mr. Hawk, this is not by way of any acquisition process. This is by direct purchase system. Where the landowner, if the landowner agrees, what is the name of this petitioner? Vipjyoti Das.
My lord, Dipjyoti Das.
At which serial number his name is appearing?
Lordship, I tried to find out by name, I could not, my lord, probably.
27.
Tag number,
27.
serial number 27. We have
Serial number?
award
27.
27 is one Kulen Das.
Yes, so
26. Vipjyoti Das.
Yes.
Hiren Das.
Hiren Das and Dipjyoti, yes.
That is 26.
Both the brothers, my lord.
But have you consented?
No, my lord.
Huh?
Not consented, my lord. Because, my lord, the petition.
Because see, Mr. Hawk,
My lord.
I think a direct purchase system here is. Now page 20. Page 20.
Yes, my lord.
See, all concerned landowners are informed that as per decision of the district level land purchase committee Borpeta, lands of these villages for the project is arranged through mutual understanding.
They had consented to,
Huh?
they had consented, they had no objection on the land, my lord. But the way they have fixed the rate, my lord. On the rate, my lord, they have raised objection.
Miss Borman, only you have to see whether he has consented.
Lordship, that form B and form C, my lord.
Form B and Form C.
Form C.
If they have consented, then they cannot raise this
Great,
question.
my lord.
It is like they have
Agreed to that,
agreed
my
to
lord.
it.
Otherwise, it will for land acquisition.
Yes.
Per scheme, my lord.
Yes. If
I
they
will
have
print it,
consented, end of the matter.
Lordship,
If they have not consented, but DC, Direct Purchase Committee,
my lord.
has unilaterally fixed the amount, then they have a case.
My lord.
Otherwise, they do not have a case.
Right.
If they have consented, let us see.
नाही अवार्ड कॉपी आता है फोटो मोस्ट कॉपी आता Order copy to the petition. पहले केस हो गई थी और compensation के लिए इससे साइन करा के तो दे सकते हैं। अब अगर अवार्ड के पास मशीन का वो डिसीजन है। एक नोट है इंस्ट्रक्शन तो वो डिसीजन है to the petition.
Mr. Hawk, you have to go through a notification dated 20 January 2021 to set up your case.
20 January.
Then only we can proceed further.
Fine.
See this notification. Have a look,
Right.
get it downloaded, then find out your case.
Right.
Otherwise, if you have consented, the procedure was followed, then end of the matter.
And in fact, my lord, they have raised objection also, my lord, page 28, my lord, they did not act on
Page?
this. 28, my lord.
28,
Yes, my lord.
15 October.
Perhaps award copy is signed prior to death.
You file your response.
My lord.
It is admitted that there are 17 lessa is going to be taken over,
My lord.
whether they have consented or not in the proper way. If there is no
My lord.
consent, then you have to take it over as per the Act
LA
2013 Act.
13.
That can be compensated later on also
My lord.
by directing them. So we'll issue notice at this stage, file your response.
My lord.
Heard Mr. S. Hawk, learned counsel for the petitioner. Who is for railway? Miss K. Kukan, learned Central Government Council for the respondent number 1 and 2. And Miss M. Bormon, learned Junior Government Advocate for the respondent number 3, 4, and 5. First of para. The petitioner has claimed that he, along with his brother, is a co-owner of a plot of land measuring 3 kathas, 13 lessas, covered by dag number 485 and patta number 263, situated ward number 5, Horbuk Town, Bornagar Revenue Circle, District Borpeta. Full stop. The petitioner has claimed that he is in occupation and possession of the said aforesaid parcel of land. Full stop. Para. The petitioner has stated that by notice, by notice, do you have any date of this?
My lord,
Page 20?
it is dated
By notice issued by the
8 October 2024.
8th of
October 2024.
2024. By a notice dated 8 or 10, 2024.
Yes, ma'am.
Within bracket annexer B. Comma, the respondent number 3 proposed to acquire B 1K 19L, a parcel of land measuring 7B 1K 19L, for a project, quote, construction of ROB in replacement of railway level crossing gate number SK-38 at RLY KM 288/5-6 at Sorbuk, Borpeta district, Assam, under construction of ROBS on 50:50 cost sharing basis, unquote. Under direct procurement through mutual understanding, full stop. The petitioner has stated that an area of 17 lessers out of the petitioner's own land has been sought to be acquired for the project under the direct to direct purchase. At a price of rupees 20,27,250. Full stop. It is the case of the petitioner that the proper procedure for acquisition of the land was not followed. Full stop. Moreover, the price fixed at rupees 20,27,250 is much less than the current market value of the category of land which falls under
Second class commercial. Second class business land.
page
It's 25, my lord. They have already.
second class.
Yes, second class
Business.
commerce. They wish commercial.
Second class business.
Commerce, yes.
Second class business. First. Issue note, Ms. Borman, learned junior government advocate appearing for the state respondents, has submitted that the area of land measuring 7B one K 19L has been sought to be acquired under the policy on land acquisition through direct purchase by way of negotiated settlement. Full stop. Whether the petitioner has consented for acquisition of the area of land measuring 17 lessers and has agreed to the price proposed would be answered in the counter affidavit. CS does sought for time to obtain instruction and to file the counter affidavit on behalf of the state respondents. Issue notice returnable on so and so. As Ms. Fukan for 1 and 2, 1 and Ms. Borman 3, 4 and 5, no formal notice. Extra copy during 3 working days. Para. The matter of acquisition of 17 lessers, petitioner 17 lessers of land and the fixation of price at rupees 20 lakhs so and so would be subject to the outcome of the petition.
The Another repetition, my lord, pertaining to the same subject matter, my lord, is pending, my lord. May I pray for a listing along with that, my lord? Another repetition is pending, my lord.
Let it come on the fixed date thereafter.
Right. I'm obliged.
8-6.
Yes.
May it please your lordship. My lord, the present contempt case has been filed against the learned technical member of the Railway Claims Tribunal, my lord. My lord, in this, my lord, the Railway Claims Tribunal consists of two division bench, my lord, technical member and judicial member, my lord. My lord, our Honorable Gauhati High Court in various instances have held that the technical member do not have power to adjudicate the matter singly in absence of judicial member, my lord. Subsequently, my lord, there was an order passed by the chairman stating that the judicial member, my lord, gave a resignation and the chairman passed an order giving power and authorization to the technical member.
Which is the impugn order?
My lord, Annexion 9, page number 53, my lord. The order of the chairman was suspended by the Honorable Court, stating that the single member do not have power to adjudicate the matter.
No, which is the impugn order?
Uh,
Against which you are saying that contempt has been committed?
My lord. Page number 29, my lord, Annexure 2.
This is an order passed in review application.
Yes, my lord. It's a
Where is the original order?
Original order, my lord. Adjudicated by the division bench, Annexure 1, page number 19, my lord.
Page number
19.
19. Against that, railway has filed a review application.
My lord.
Then
That's
single member, that is the technical member, who has allowed the application.
Yes, my lord. In absence of judicial member.
Review is allowed and your original application has been dismissed.
Yes, ma'am.
Now, why this contempt?
My lord, the tribunal consists of two members, my lord, judicial member and technical member. My lord, our Honorable Gauhati High Court in 234 judgments have held that the technical member do not have power to adjudicate the matter singly in absence of judicial member. Subsequently, my lord, the judicial member of our tribunal has given a resignation and the chairman has passed an order. My lords may look upon the order of the chairman, which granted power to the technical member to adjudicate the matter singly in absence of judicial member, my lord. Page number 52, my lord. This was
Mr. Rathi.
Yes, madam.
Firstly, you have gone on a wrong tangent. If a contempt is committed
Yes, madam.
by the technical member, then he has to be sued by the name. Right. By the name, not by learned technical member of Railway Claims Tribunal in a contempt petition.
Right.
Right. Second question is, when the original judgment has been rendered
Yes, my lord.
by a division bench,
Yes, madam.
right, by no manner in whatever, whether review power is there or not, that is to be examined.
Yes,
but that division bench judgment cannot be reviewed by a single
Yes, my lord.
bench.
Right.
Right.
Yes, madam.
Then if review is to be allowed,
Right.
then original judgment is to be recalled.
Yes, madam.
Then original application is to be reheard.
Right.
Here, single bench has recalled a division bench judgment
My lord.
and thereafter dismiss the original application.
Yes.
If such a power can be assumed by a single judge, then this court also, with the same jurisprudence,
My lord.
can also set aside a judgment of the division bench here. Right? Question is not about contempt.
My lord.
Question is about assumption of jurisdiction, be it review, to set aside or recall a judgment of the division bench, and thereafter, by the same order, without hearing the parties on the original application, dismiss the original application. It is not a, and your petition is structured wrongly. If any contempt petition is preferred, then this has to be by the name, not by the office.
My
Secondly, be it there, whether single bench can allow or not by notification, these judgments are there. But for the case in hand, it is the assumption of jurisdiction of review by a single judge to reverse a judgment of a division bench, which defies logic
My
and law. And at the same time, by recalling it, to dismiss the original application. After recalling the judgment by review, parties are to heard afresh on the original application. Thereafter, by another revision judgment, it has to be either allowed or disposed of, dismissed. So your everything is wrong.
If my lords may
I'm dismissing it.
my lord, the writ petition, our Honorable High Court suspended.
I have gone through contempt application. First wrong you have committed is that making the office as a respondent in a contempt petition. You have a very good case for recalling this, for challenging the order, but this is not way of contempt jurisdiction.
If my lords may grant me liberty, I'll just withdraw and file a fresh. my lord.
Yes,
I'll
it is
file a
up.
fresh
Yes.
one, making personally the party.
Then also it will be dismissed.
I'll satisfy my lord in that angle.
That will be also limine. I am telling you.
If my lords may just look upon the.
Heard Mr. D. Rothi, you file it. It is your option to file in any manner, and it is for court's discussion to whether to accept or not to accept. Heard Mr. D. Rothi, learned counsel for the petitioner. Mr. Rothi has submitted after hearing, Mr. Rothi at some length, Mr. Rothi has submitted that the petitioner be granted leave to withdraw this writ petition in order to file it afresh in proper form. First of, in view of the above submission made by Rothi, this petition stands dismissed on withdrawal with the liberty as prayed for.
I'm grateful, my lord. Much obliged.
I'm sorry for sitting this result into this lordship. Lordship, actually, I am
No allow.
I'm on
No audience.
I'm on dialysis, lordship.
On no audience, Mr. After mention of no audience.
Item number 4.
Lordship,
Yes, Mr. Mozumdar.
authority was granted me to file additional affidavit annexing the order sheet of revenue appeal number 1. Then I have received the order sheet just today earlier, Lordship. I'll file.
You want to file?
Yes.
How much time you need?
Only 3 and 4 days.
Okay, heard Mr. F.Z. Mozumdar, learned counsel for the petitioner, and Ms. M. Borman, learned junior government advocate. Some for the state respondents. Mr. Mozumdar has submitted that Mr. Mozumdar has sought for listing of the case after 1 week in order to file the additional affidavit in reference to the order dated 31/3/2026. Post of the prayer is allowed, list the case on so and so. Give a date on the next one.
1505.
Item 6.
May it please the Lordship.
Yes.
Lordship, my prayer is very limited in this division.
Limited.
Though it is a petition for issuance of OR and go. Lordship may take your Lordship to section 62, Rule 62, 4A of the Assam Panchayat Constitution Rule 1995.
Rule 62.
262 clause 4A.
Assam Panchayat Constitution Rules.
1995.
62. 62,
Subclause 4A.
4.
4 subclause A.
Subclause, subject
May I read,
right,
Lordship?
filing nomination.
Subjected to the
Regarding
proce-
the age at the time of their marriage, failing which.
the concerned candidate shall be disqualified. I will come to C, Lordship. The Gaon Panchayat Secretary, on receipt of information of such underage or minor marriage in respect of the President, Vice President, or member of the Gaon Panchayat, shall inform the matter to the concerned Block Development Officer, who in turn shall inform the concerned District Commissioner through the Chief Executive Officer, Jilla Parishad. The concerned District Commissioner shall examine the matter and, on establishment of facts, shall remove the President, Vice President, or member of the Gaon Panchayat concerned accordingly, with an intimation to the state government as well as the State Election Commission. So, Lordship, this section provides for an inquiry by the Deputy Commissioner on receipt of a report of the BDO. Lordship, the allegation of
What is a disqualification? A is,
Lordship.
it was
Age is
necessary for the candidate to furnish an affidavit regarding their age at the time of marriage. So this is a compliance rule.
Yes.
That if in the affidavit, he has to mention regarding his age at the time of marriage. Right? What is the
Lordship.
wrong?
Yes. There is nothing wrong in that, Lordship.
If it is
Lordship,
found
there is
that
the
you
disqualification to a member.
you have to read B then.
Yes.
You have to read B.
B also, Lordship. Yes.
Is it not?
Yes, Lordship. B says
That he or his spouse was underage at the time of marriage.
So, Lordship, the allegation of the petitioner stems from the fact that the petitioner's first son, the son of the respondent,
Petitioner
number
or
seven-
respondent?
the respondent number 7's first
Who is
son,
respondent number 7?
7. Lordship, he has been selected as the elected as
What
the
is his
member
name?
of the ward. His name,
Kaidul Haq Law Score. Yes.
yes,
He is a Gaon Panchayat member.
member, Lordship.
Elected.
Elected, Lordship.
Yes.
Now, Lordship, may I just take a Lordship for a few documents. Lordship may first
His
Sir.
affidavit.
his affidavit, Lordship. In his affidavit,
Mhm.
he says that he was married on
Where is that affidavit?
page 37, Lordship.
Page 37. Yes.
Lordship will turn to clause 4.3. That my date of birth is so and so. I got married with Srimati so and so.
Where date of birth is so and so. This is in
2040.
2025.
Yes,
And I got married.
on 6/4/2040. Lordship will turn to the next page.
Just a minute. Let me read.
I'm sorry, Lord.
So he says that at the time of marriage, 25 years.
Yes, he was 25 years.
Ah.
And he got married on 6/4/2040.
Hmm.
Now, Lordship will turn to the next.
Whether he has to say in the affidavit about the marriage of his wife? I don't think so.
He doesn't have to say that.
Okay.
Lordship will turn to the next page at page 38. This was a declaration of marriage of the respondent with his wife. Lordship sees down below clause 2 from bottom line number 3. Accordingly, our marriage was solemnized on 16th day of December 2014.
Yes.
He has also annexed the certificate at page 43 issued by the notary, which says that their marriage took place on 16 December 2014. Lordship, for a moment, Lordship turns to page 40. 40. Lordship sees the seal on the top.
Page?
Page 40. Lordship sees a seal on the top. The date on the seal is 28 November 2014. And this was signed by the notary on 26/12/2014, a month later. Now Lordship turns to page 47.
Forty-seven, yes.
47. Lordship will find in the third column, the date of birth of their first child is 6/3/2014. This is a copy of the NRC. At page 48 is the original.
Yes.
So Lordship sees the date of the birth of child is 6/3/2014, and his marriage apparently took place after his child was born. Next page, your Lordship may turn to page 49. This was obtained through the RTI. Lordship will see the date of birth of the first child, Fahima. And so date of birth is 6/3/2014. Whereas in his affidavit at page 51, he has given the date of his child, date of birth of his child, first child as 6/3/2015. These facts created a doubt in the mind of the people out there that this person was involved in the offense of child marriage with his wife, which is a disqualification under the Act as well as the rules. So
No, question is Rule 62.
Lordship.
2B.
Lordship.
And read with C.
Yes.
A person would incur disqualification under this rule
Yes.
if his wife was underage
Lordship.
at the time of marriage.
At the time of marriage.
These are discrepancies regarding the marriage, date of marriage, and the date of birth of the child. This could be a case which do not come directly under this rule.
Yes, Lordship.
This could be a case of election petition.
No, Lordship, this could be a case
Sorry,
of
my lord,
election petition.
may I submit one thing, my lord, to save the time, my lord. Interpreting these clauses, my lord, already similar matter has been dismissed, my lord, saying that, my lord, these are not covered under, my lord, in case of only, my lord.
Underage of the wife.
Yes.
Or underage of the candidate.
Yes, my lord.
But these discrepancies would not come under the purview of this rule.
Lordship. But the rule
From clear reading, it is
Lordship,
evident.
Lordship, because the rule says that a video.
This is a rule for if the candidate was underage at the time of marriage or his spouse was underage at the time of marriage. Not regarding this discrepancy.
Not regarding. Lordship.
After his election, if you want to allege that he would incur disqualification, that would be by way of election.
An election petition, Lordship. Lordship will turn
not even co-warrant would
65.
apply.
In fact, my lord,
No,
this
Lordship,
court
I'm not
holds,
praying
my
for
lord,
a co-warrant also.
only
Lordship
of
will turn to
those
page
cases
64.
which has been after acceptance of the notice, that only writ petition is maintainable.
Yes.
Otherwise, district commissioner does not have any jurisdiction.
Lordship,
They
page
have- they have not-
64
this-
is the report of the BDO, which was forwarded to the deputy commissioner.
Say me about something about underage of the wife of the candidate.
Lordship, underage of the wife, we are saying the allegation is that the wife, there is
There is nothing.
of documents.
And
Lordship,
rule,
that can be found out by the deputy
rule
commissioner.
D says, C says, underage or minor age.
Yes.
It is very clear.
Yes. Lordship, to that extent, I agree, Lordship. Lordship, there is a report of the BDO which was forwarded to the deputy commissioner.
No, if it does not come within that purview of the rule, why should we waste our time? There is nothing about underage of the candidate or of the wife.
Or of the wife. Lordship,
Discrepancy about the date of birth and date of marriage.
date of marriage.
Yes.
Lordship,
Is there any
that-
pleading that the wife was underage?
Yes, Lordship.
Because
we are saying that the date of marriage has been subsequently manipulated so as to
no,
bring him out.
whether she was underage
Lordship,
and
there-
anything about the,
Lordship, the question,
because his date of birth is clear.
Lordship, the wife's date of birth. is
His
also
date of,
clear.
the candidate's date of birth,
Yes.
you said something.
There is no dispute about the candidate.
28/9/1988.
Yeah.
So if you go by that, he was, if it is within 2014,
Yes.
any date, he was 24.
Lordship, to be very fair, Lordship, even the wife of the
6 years.
date of the birth, the date of birth of the wife is also permissible. Like she has crossed 18 years. As per the certificate which we have annexed, we have not suppressed anything.
Then it is
Lordship,
not.
the only question is the date of marriage. We say that these are manipulated.
Oh, that is not, it would not come within that rule.
Lordship, let the deputy commissioner contact an.
No, why should the state machinery used to be involved for this when it does not come within the rule? No, Mr. So there may be some other remedy, but not under this rule.
Lordship may be permitted to withdraw. We'll approach the appropriate forum if required.
Heard Mr. M. Das, Learned Counsel for the petitioner, Mr. S. Dr. Learned Standing Counsel, Panchayat and Rural Development Department for the response number 1, 2, 4, 5, 6, and Miss M. Borman, Learned Junior Government Advocate Assam for the response number 3 and 8, full stop. After hearing Learned Counsel for the parties at some length, Mr. Das, Learned Counsel for the petitioner, has submitted that he may be allowed to withdraw the petition in order to seek appropriate remedy permissible under the law. Full stop. In view of the above submission made by Mr. Das, Learned Counsel for the petitioner, the petition is based on withdrawal with the liberty to the petitioner to avail appropriate remedy permissible under the law.
Madam, I have shared those judgments to the court master.
Okay, give it for our benefit, so that we do not have to proceed before beyond motion stage.
So, my lord.
Yes.
Highly obliged.
Item 6.
6, please.
For item 7.
Yes, Mr. Mohanto.
This must have filed an application before the deputy commissioner long before Lordship for it is 4/7 to 2020.
Before Deputy Commissioner.
Deputy Commissioner.
Yes, Mr. Das, why don't you take instruction?
Page 34.
Page 34.
This has been filed by me, Lordship, for reminder.
So why don't you take instruction from Deputy Commissioner Nogam? Maybe 1 week. Whether he is disposed of or not. If not disposed of, there is a time limit expected.
Yes.
Correct? That heard Mr. D. Mohanto, Learned Counsel for the petition, and Mr. N. Das, Learned Junior Government Advocate for the. Oh, okay, Mr. Bhotaseji is there. Oh, how many petitioners?
Petitioners, does be
Okay, many
many.
petitioners. And Mr. A. Bhotaseji, Learned Junior Standing Counsel, Revenue Department for the response number 1, and Mr. N. Das, Learned Junior Government Advocate for the response number 2. First of the grievance of the petitioner is that they have filed an appeal before the response number 2 under Regulation 147 within bracket B of the Assam Land and Revenue Regulation 1886 on which date?
On 4/7/25.
4/7/2025, which appeal has been registered as application number page 34 of the same. Despite being registered as this, which application, despite being registered as so and so, has not yet been heard and disposed of. First of para Mr. Das, Learned Junior Government Advocate, appearing for the response number 2, has submitted that he may be allowed to take instruction as to whether the appeal.
Specific instruction on my lord, Annexure 7. Page 34.
That is what application number, whether the appeal registered as so and so as to why the appeal registered as so and so has not yet been whether the appeal has been disposed of or not. If not, then what would be the expected time period within which the appeal can be disposed of? List the case accordingly on so and so. Next week.
1505.
Mr.
15 minutes.
Mr. Mohanto, Learned Counsel for the petitioner, shall furnish a copy of the
1805.
petition along with annexure to Mr. Das during the course of the day to enable Mr. Das to obtain the necessary instructions.
Extra copies.
1805. Item 8.
Just a minute. Branch of others. Whether the parcel of land in respect of which the petitioner has alleged encroachment is a village grazing land.
Yes, Lordship.
Classified as village grazing land. Because you have used the word village grassing land. Whether it has been classified
Not
as a village grazing land.
not classified, Lordship, but
Not classified.
yes.
Then how can you institute such a writ petition?
Lordship,
If it is a village grazing land classified under the regulation, then definitely your right to use the VGR land would be affected. But if it is not a VGR land, but merely government land,
yes, Lordship.
somebody has encroached with which you don't have any interest. This could be a PIL maybe, but not writ petition. What legal right of the petitioner has been infringed? If I allow, anybody can file an application that this man has encroached. I can cite a case of District Nagaon, this man has encroached. So let us file a writ petition. Whereas you are a resident of Kamrup district, Gauhati. If it is a classified village grazing land or professional grazing land, and that respondent has encroached, then definitely your right to use the VGR land is to be affected. But somebody has encroached government land with which you don't have anything to do. How can you say?
Villagers were not before this honorable court, my lord.
Right, some organization.
Moreover, my lord, the representations were filed on 17/4 and my lord 24/4. Only 10 days, my lord.
You make a statement whether it is a classified village grazing land. Then only, have you made any statement, Mr. Das?
No, no, my lord, not classified, my lord, but they are saying that village grazing.
No, it cannot be
Yes,
because
yes.
all are notified.
Yes, yes.
There must be in the revenue records, it will be VGR. Show us that it is VGR, and definitely we will issue notice.
Lordship,
Are you in a position?
Lordship, my senior is not there today, Lordship.
Huh?
My senior is not there today,
Okay,
Lordship.
heard Mr.
A.R. Mondal.
A.R.
Mondal.
Mondal, learned counsel for the petitioner. A. Aforesaid,
1 month.
learned standing counsel, revenue department. For the respondent number 1, Mr. Andas.
2, 3, 4, my lord.
Learned junior government advocate for the respondent number 2, 3, or 4. Full stop. The petitioner has alleged, in this petition, the petitioner has alleged that this 5 and 6.
Yes, my lord.
Okay.
2, 3, and 4.
No. They have encroached. 5 and 6. Why they have made parties?
Yes, yes.
Yes.
Yes,
The
my
respondent
lord.
number 5 and 6 have encroached.
No. 5 have sold the land to respondent number 6. And now present, according to the petition, 6 says encroachment.
And respondent number 6 has encroached upon a parcel of land, which is a village grazing land. However, the petitioner has not annexed any document in support of the claim that the encroached land has not annexed any document. What is this base 13? Why they have annexed it?
It's a Rajan.pro, my lord. That is
Why? What is the significance of this annexure?
my lord, the 5, my lord. He was the earlier owner of the tea garden.
Oh, that is their land.
Yes, yes, lord.
Respondent's land. Has not annexed any document pertaining to the land. Where from? It can be seen that the alleged encroached parcel of land is either a village grazing land or professional grazing land. Within bracket PGR and PGR, PGR or PGR. The petitioner is granted an opportunity of 1 week to substantiate its claim that the alleged encroached parcel of land is a PGR stroke PGR land. Lays that by bringing on supporting document by way of an additional affidavit. Lays the case on next week, Friday.
1505.
Highly opposed.
Item 9. Well, not at this stage, we are praying for a notice. Then the other side file their counter.
Okay. Mr.
J. Bora for 2, 3, and 4.
Standing counsel.
Yes.
Heard Mr. K. Chodri and senior counsel. Stated by Mr. J. Kolita, learned counsel for the petitioner. Labor Welfare, Mr. N. Das, learned junior government advocate Assam for the respondent number 1. Mr. J. Bora, learned standing counsel ATEEFO for the respondent number 2, 4. 2, 3, and 4. Post of the petitioner agreed by
204 million.
204.
That same day expression of interest was called for, same day appointed.
Pagination is not there in 204. Okay.
Annexed
Agreed by
16, 6, 10, 25. Siddhesh
agreed
Gupta.
by the manner in which a receiver has been appointed by an order dated. What is the date?
Actually, my lord, 6, 10, 25, but possession was given on 26, 26, 9. That statement we have made, my lord.
Okay.
Certificate of 26.
Agreed by the manner in which a receiver has been appointed by an order dated 16/2025, the petitioner has instituted a writ petition. First, the petitioner has further that has been taken over.
Yes.
Okay, has alleged
On 26/9 itself.
has assailed the taking over of the
Tea state.
tea estate belonging to the petitioner. First of the matter of required consideration, issue notice returnable on so and so date. As Mr. Das has appeared and accepted notice on behalf of the respondent 1 and Mr. Bora, standing counsel ATPEFO, has appeared and accepted notice on behalf of the respondent 2 to 4. For no issuance of formal notice to the said respondents is dispensed with. Extra copies, however, the counsel for the petitioner shall furnish extra copy, requisite number of extra copies of the writ petition to the learned counsel for the said respondents within 2 working days from today. The petitioner shall take steps for service of notice upon the respondent number 5 by speed post within 2 working days from today. The respondents shall ensure that their respective counter affidavit is filed on or before the returnable date. That's
Item 10.
Yes.
Your Lordships. Your Lordships, I have challenged in this case the order passed, Your Lordships. Page 20, Your Lordships.
Page 20.
Page 22 is
Summary so-called notice. Under section 73.
Your Lordships, there is no concept of summary so-called notice in 72.
An order has been passed.
22, page 22, Your Lordships.
Page 22.
And all this, Your Lordship, notice and order.
23.
Your Lordships.
And 34. Okay, one is that. Then
Second, Your Lordships, neither the summary so-called notice nor the Your Lordships, this order passed under 73 are signed by any of the proper officers.
Then your registration has also been cancelled.
My registration has also been cancelled, suspended, Your Lordship.
Suspended.
Suspended, Your Lordship.
Show cause notice. Yes, Mr. Chaudhary.
Lordship.
Summary so-called notice. I think there is a order already.
Yes, already order that has been gone on appeal, Lordship, by the CGST, and that is pending, Lordship.
Before
the division bench one, Lordship.
Before division bench. But if, there is no stay order.
Lordship, that information I do not have.
Get your instruction.
Central government has preferred the
Central government.
Yes, sir.
Okay. Mayor pendency before a higher forum is not.
Yes, they are
right.
Lordship. And secondly, Lordship, here the so-cause for cancellation, it was issued on 8th of January. And Lordship, he had enough time to give his
respond.
He didn't respond.
Why you are not responding?
And even if he can go on appeal also, that limitation was also there.
Your Lordships,
for this so-called notice, the registration is liable to be cancelled for the following reason. But this is vague.
No, Lordship.
On the face of it, it is very vague.
Lordship, it is written that unpaid liabilities. In all probability, the summary so-called that liability
proceeding,
maybe, Lordship.
If this goes, then that will go.
Yes, Lordship. At least he could have responded that already decision.
But
he has not.
First, the responsibility is yours.
Yes.
If summary, okay, find out whether any stay order is operating.
Yes, Lordship.
In that case, there will be some difficulty on the part of the single judge. But if there is no stay operating, we can follow the our previous order.
Yes, Lordship.
And thereafter, fate will be decided after the judgment of the division bench. Take your instruction whether stay is operating.
I will take that.
Any order regarding summary so-called notice?
Your Lordships, I have an order.
Please hand it over so that we can have the opportunity to go through it. There are more orders. No? Give it to me. Okay. I'll have my own order. Part Mr. N. and Jha, learned counsel for the petitioner, and Mr. B. Chaudhary, learned standing counsel, finance and taxation department, Assam, for the all the respondents.
Yes.
The petitioner was served with a summary of so-called notice for the dated 18/12/2023, within bracket Annexer 2, for the financial year 2018-2019 under section 73 of the central, it will be Assam
Yes.
Your Lordship.
Assam,
Yes.
Assam Goods and Services Act, 2017.
Yes.
And thereafter, by an order dated 30/04/2024, the petitioner has been saddled, SADDLED, saddled with a liability of rupees 15,53,230 by way of a summary of the order. This is also summary.
This is also summary, Your Lordship.
Okay. Full stop. Subsequently on 8/1, that is Annex 3, huh? Subsequently on 8/1/2026, within bracket, Annex 4, the petition has been served with a so-called notice for cancellation of registration on the ground of unpaid liabilities, and its registration has been suspended WEF 8/1/2026. Full stop. Para. The Learned Counsel for the petition has submitted that the manner in which, more particularly, by way of a summary of so-called notice and by way of a summary of an order, purportedly under Section 73, AGST Act, the respondent authorities have acted clearly in violation of the statutory prescriptions contained in the AGST Act, and the issue is covered by judgments of coordinate benches. First stop. Issue is covered by various judgments of various judgments. First up, Mr. Chaudhary, Learned Standing Counsel, Finance and Taxation Department, Assam, appearing for the respondents, has submitted that after the judgments rendered by the single benches, the matter has been taken up before the division bench by the CGST authorities by way of an appeal, and the matter is pending presently before the division bench. So stop. He has sought for a week's time to obtain instruction whether any stay order is operating in the appeal presently lying before the division bench. Full stop. As sought for by Mr. Chaudhary, lays the case on next week.
Your Lordship, to satisfy. Your Lordship, apart from this
week, huh?
apart from summary surplus notice, Your Lordship, here it is also a question of limitation, Your Lordship, because the order was passed beyond limitation, Your Lordship.
Okay.
So both
Mr. Jha, submission likho. Mr. Jha has further raised the issue of limitation of issuing the summary of so-called notice on
and the order, Your Lordship,
on 18/12/2023 for the financial year 2018-2019.
and order, Your Lordship, order.
Okay, that will do.
1305. Item 11.
Mr. Chaudhary, you need a copy? Extra copy, no? Only the stay order.
Yes.
Yes, Mr. Das.
Yeah, Lordship. Matter part in Lordship, the land acquisition, Lordship. So, herein Lordship, the 7 matter has been are pending before this honorable court, Lordship, and that has fixed on 21st, Lordship. Another 7 matter already pending before the honorable High Court, Lordship. Same allegation, Lordship.
Same.
Yes.
Okay, let me read your synopsis. Right.
Yes, sir.
Single petitioner here.
Yes, single petition, Lordship. So let me
Single
start
petition.
the year of 2001, Lordship.
Just a minute.
Yes, Lordship. Then measuring three legal 1.34 lakhs, Lordship. The well settled, Lordship, absolutely.
So have you received compensation or you have not received?
Not a single penny I have received.
So why you are making the calculation?
Lordship, one thing is the Lordship. So
No, you are making the calculation
Lordship,
under this amount. Okay.
So
You have
far-
not received any compensation.
not received.
Okay.
So far as para 3 is concerned, my lord,
Para 3 of
this petition, my lord.
writ petition.
They have filed an earlier writ petition also where it was withdrawn on 17/3/2026, my lord. So far as liberty is concerned, my lord, that was objected by the state and accordingly, this order has passed.
Page
17.3.
Kindly see this order, my lord.
Liberty was granted, Lordship. So there was some clerical mistake, Lordship. So
No,
that's
no.
why the writ petition was withdrawn,
Order
Lordship.
reflects something different, my lord.
And thereafter, Lordship, so I have filed a representation, Lordship.
Have you stated in this writ petition?
Yes, Lordship. I have
Which paragraph?
3.
Paragraph? Paragraph? 3. This is
And
3.
five, Lordship, 5.
1 minute. 3097.
So, Lordship,
1 minute. This is 2024.
the year of 2024, Lordship, I have filed. So there are some clerical mistake, Lordship. So the actual Lordship.
No, question is about granting liberty. This is wrong. Paragraph 5 is wrong. Wrong statement.
3 also, my lord.
Huh.
Paragraph 3 also. Because
this
I
is
could
wrong
find
statement.
liberty in the earlier order. Withdrawal was permitted, but filing afresh.
Liberty to file, Lordship.
Where is that? In order, I have been.
Lordship, last line, Lordship, kindly file, Lordship. So the as well as the petition last line, Lordship, that we
Liberty.
are number 5, Lordship.
Huh?
So with withdrawal on with liberty to
No, that is a wrong statement.
liberty.
That is
liberty
outrightly a wrong statement.
There is nothing wrong statement.
Is it not? No, no. Question is about the petitioner's stand.
Yes, Lordship.
Now you have said with liberty to file afresh. Withdrawal, it was indispensable to withdrawal of the, I don't know this thing. Plenty, but the petitioner came to know content of the writ petition had been plenty inadvertently clerical mistaken. So it was indispensable to withdrawal the said writ petition as well as ditto WPC 3097 has withdrawal on 17/3/2026 with liberty to file afresh.
Yes.
But that word is clearly missing in the order dated 17/3/2026. It has been rejected. The liberty sought for to file afresh has been rejected. Plus, only if
New cause of action.
a fresh cause of action. Now, submission of a representation is not a fresh cause of action.
So, Lordship.
See Jacob,
Lordship, with due respect, Lordship, so Article 300A, Lordship, of the
I understand, but before that, why this order can be appealed? Because this thing has been recorded. This thing has been recorded after contest. No, not possible.
Technical issue, Lordship. So
Not
liberty.
possible,
liberty-
Mr. Das.
Liberty is granted, Lordship.
No
So a
granted.
person should not be deprived, Lordship.
Please read loudly, sir,
So, have copy, Lordship.
for all benefit of all.
Copy, Lordship.
Please.
So, last paragraph, Lordship.
Last.
Under the aforesaid circumstances, while this
Under the aforesaid circumstances.
Yes, Lordship. While the writ petition is dismissed on withdrawal, it is made clear that only on a fresh cause of action, the petitioner would be liberty to approach this court, Lordship.
So your prayer for liberty was rejected. Fresh cause of action.
Yes, Lord.
Right.
So there are
Fresh cause of action is representation, according to you.
Yes.
And this court is of the view that mere filing of a representation or repeated representation is not a fresh cause of action.
Lordship, not repeated, Lordship. So I have filed a representation.
Fresh representation is also not a fresh cause of action.
It's just technical issue, Lordship.
No technical.
So, Lordship, the person.
No, sir, no technical.
72 years
I understand.
72 years old,
You
Lordship.
are a fence sitter. When the other petitioner got some relief, so you have jumped into the fray.
No, Lordship.
But question is, how can we overcome this order 17/3/2026? It has to be appealed. Get the thing corrected. That my rights have been treated indifferently.
Lordship, I'm sorry for that, Lordship. So the last line, the petitioner would be.
Sir, then I am closing. I have indicated to you enough. Ms. Chakraborty, I have indicated to him enough, and no more indication. Yes, I'll pass my order.
Submission I would like to make one. Paragraph 22, he says that the authorities, respondent authorities in 2001, used the matter in pending since 2001, and now he has come after 25 years, is his own statement.
Paragraph?
After 25 years, now he has come before this court. Paragraph 22, page 31.
Yes, it can be reopened. There is no doubt. Yes, even there are many. There are many judgments this side, that side. Even after, say, a widow has been allowed, a prayer for a widow has been allowed even after 3-4 decades. I am not on that. I am on that in view of Sarguja transport. If liberty is not granted, secondary petition is not maintained. So you have to correct this order. You have to get the order corrected by filing an appeal or by filing a review application. Review cannot be because already there is no question of review of this order. Only by the higher forum,
Liberty granted. Then only.
permission can be granted. This can be modified. Otherwise, think it over.
Lordship,
think it over because a statement has been made wrongly before the court.
Lordship, I admit.
So, in that case, there will be imposition of cost also. Think it over.
Lordship, we do respect. Lordship, the petitioner is aged about the 72 years old. Lordship,
Right.
Similar matter.
So, think it upon.
Already.
So, how much cost he can bear for making a wrong statement before the High Court? I have given indication. I am giving you time till Wednesday.
We do respect, Lordship. For a moment, Lordship, the last line, Lordship, the petitioner would be liberty to approach this court, Lordship.
Okay, now I am passing the order. Heard, Mr. R.C. Das. Sarguja transport to দিব C. Jacob Leras House. Land Council for the petition. And Ms. Ann Bordelou, Land Standing Council for Revenue Department for the respondent number 1 and 2. Ms. M. Bormon, Land Junior Government Advocate for the respondent number 3.
3 only.
Ms. P. Chakraborty, learned standing counsel, Water Resources Department, for the respondent number 4, 5, and 6. And any finance whose name is to be recorded? Mr. H. Olia, learned standing counsel, Finance Department, for the respondent number 7. Full stop. Era. In this writ petition, filed under Article 226 of the Constitution of India, the petitioner has projected that in a parcel of land measuring 3 biga 3 kotha 1.34 lecha, belonging to him, was acquired by the respondent authorities in the year 2001, vide a land acquisition proceeding registered as LA case number 06/2001-2002, and against such acquisition for construction of for the purpose of flood control and construction of marginal embankments in both banks of river Hajra from Patgiri Chuba to Doni Patgiri Hat, PWD Road, Torong, Mongoloi, Assam. Post of the said land acquisition proceeding was initiated under the provisions of the Land Acquisition Act 1894 as amended. Post of para. It has been brought to the notice of the court by the learned counsel for the state respondents that the petitioner had earlier instituted a writ petition. No, post of, the petitioner. In this writ petition, the petitioner has sought for a direction to the respondent authorities to release appropriate compensation for acquisition of his land under the provisions of the Land Acquisition Act 1894, read with the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013. Full stop. It has been brought to the notice of the court by the learned counsel for the respondents that the petitioner seeking the same relief, had earlier instituted a writ petition, WPC number
3097.
309
Public 2024.
7 2024, which was dismissed on withdrawal, without liberty. By an order dated 17/3/2026. And the petitioner has projected incorrectly in the present petition that there was that liberty was granted to the petitioner while withdrawing the said writ petition on 17/3/2026. Full stop. Para. In paragraph 3 of the writ petition, the petitioner has stated that the earlier writ petition, WBC number 3097/2024, 2024 was withdrawn due to some clerical errors on 17/3/2026 with liberty to file afresh. Also, the petitioner has further stated that a representation. Where is that representation?
Lordship, representation is page 55, Lordship. Annexure 4, Lordship.
A representation was thereafter
Dated 23/3/2020, Lordship.
submitted before the respondent number.
All respondent, Lordship.
No, Deputy Commissioner. Respondent number
Lordship, all respondents. Lordship.
within bracket annexure Roman 4. Before the respondent number 3.
Lordship,
On-
all respondents, Lordship. I have the
Where have you stated?
Lordship, a copy I have annexed, Lordship. Is that page 50? Receive copy. I have-
Before the respondent authorities on before I am submitted before the respondent authorities either personally or through post. Representation dated 23/3/2026.
Is speed post all there?
Post includes speed post, all post,
Is speed post.
all post. Post up. After submitting or sending the representation dated 23/3/2026, the petitioner has filed his writ petition on 27/4/2025, 6, seeking the same relief as sought in the previous writ petition WBC number 3097/2024. First of all, para. It is averred in paragraph 5 of the writ petition that the previous writ petition WPC number 3097/2024, though it is in paragraph 5 of the writ petition, the petitioner has averred as under, because I could not understand the actual meaning.
Which is
Whole paragraph
Me too.
you quote, which was very difficult to understand. Para.
Lordship, which line, Lordship? Which
I am at
I'll be
loss.
Lordship. I'll be
I am at loss to understand the language, grammar, and words used in paragraph 5. So for deciphering, some experts would be needed. But anyway, last line is clear that you have been granted with liberty to file afresh. Para. From paragraph 5, quoted above, it is evident that the petition has made a clear statement that the previous writ petition WBC number 3097/2024 was withdrawn on 17/3/2026 with liberty to file afresh. First of Mr. Das, Mr. Das has further contended that the filing of the representation has given rise to a fresh cause of action to file to institute the present writ petition. Full stop. Para. On 17/3/2026, the court had passed the following order in the writ petition WPC number 3097/2024. Quote করে দিব। Para. From the order dated 17/3/2026, comma, it is clear that only on a fresh cause of action, comma, the petition only on a fresh cause of action, comma, the petitioner has been allowed has been granted the liberty to approach this court. Full stop. Mayor, after disposal of the previous writ petition, by the order dated 17/3/2026, comma, Mayor, filing of a representation give rise to a fresh cause of action. Full stop. Fresh cause of action.
With
Full
due
stop.
respect,
Para.
I'm sorry for disturbance.
Shall I cite 20 judgments
Lordship, with due respect.
in view of the nature of liberty granted by the order dated 17/3/2026 by the coordinate bench and no second or third chance. I have indicated twice. I have indicated all the learned counsel for the respondents indicated in court to you, but you did not relent, right? So court had no option but to pass this order. Otherwise, yes.
The petitioners may not seeking a direction to the bank authority to defreeze their bank account, my lord.
Heard, Mr.
M. Ali.
Ali and counsel for the petition. Most of the petitioners have stated that they are operating a bank account number so synopsis at they're maintaining a bank account number so and so at Patchala branch Borpeta of the State Bank of India. First up, but the respondent bank authorities have put the bank account on hold on the ground that there is a disputed transaction of rupees 1,61,179.87. So the petitioners have raised that the account has been blocked without issuing any notice, stroke intimation either by the respondent bank authorities or by any investigating agency. Issue notice returnable on so and so. Steps upon the respondents. The petition shall take steps upon the respondents by speed post within 3 working days from today.
8 June, 806. Item 13.
13 also similar, my lord.
Okay. Account number to আছে ইয়াতে Borpeta Road Branch Borpeta. Transaction 1,76,000. 17,63,141.
Yes, ma'am.
You don't know by whom this has been put on hold?
My lord, the bank authority says they are higher authority as per direction of their. All right.
Item 14.
Yes.
In this matter, notice may go, my lord. There is here, my lord.
Miss aforesaid, learned counsel for the petitioner. Post of the petitioner. Comma, petitioner, comma, not comma, has instituted a petition agreed by non-implementation of revised staff salary in terms of the memoranda of settlement dated 7/5/2022 and 9/5/2025. Post of issue notice returnable on so and so. The petitioner shall take steps for service of notice upon the respondents by speed post within 3 working days from today.
10/06. 10 June. Item 15.
Where the lordship? Lordship, petitioner.
Bank account.
Yes, lordship, Bandhan Bank, lordship. But
Respondent did not
What
provide
is the
anything.
disputed transaction?
Lordship, bank account did not provide anything, Lordship. Why bank account didn't freeze, Lordship?
Respondent number 3 is not required at this stage.
Lordship,
Why respondent number 3 is required?
Lordship.
One current account number. So maintained at, oh sorry, at Borpeta Road Branch, Borpeta, Agorton isne. We have issued notice or intimation. Any disputed amount?
No, Lordship. No.
Okay. Nalage, headline nalage. Issue notice, huh? Same date.
8/6, 8 June.
Steps.
I'm
Upon the petition shall take steps upon the respondent number 1, 2, and 4. Let notice be issued to the respondent number 1, 2, and 4. Returnable on so and so. The notice is not issued at this stage to the respondent. Notice is not required to be issued at this stage to the respondent number 3. A petitioner shall take steps upon the respondent number for service of notice upon the respondent number 1, 3, and 4 by speed post within so and so. Same.
I'm deeply obliged.
Item 16.
This case, he's on legs at court number 19. The timing, my lord. Possible.
Item number 17.
May it please Your Lordship. Lord, we are challenging the action of the district commissioner in interfering with a private contract and also the action of the sub-registrar registering a deed. If I may just very quickly place the background, Lord. The petitioner and the respondent number 6, Lord, they entered into an MOU, which Your Lordship finds at page 56 for sale of a particular tea garden, the bearer plans, and a specified list of fixed assets. That MOU, Your Lordship finds at page 56. That was between the petitioner and the respondent 6. Now, my lord, pursuant to this MOU, the permission was sought from the government for sort of entering into the agreement for sale and finally conveying the property to the respondent number 6. That permission was accorded on 14/11/23, which Your Lordship finds at page 73. Page 73, Your Lordship finds this is the NOC for agreement of sale and power of attorney between APJT Limited and Khobong Tea Estate Private Limited. Therefore, I would request you to incorporate the conditions to be complied with. Now, on the following page, Your Lordship finds the conditions. They're 4 in number, page 74. Just quickly read this one. Condition number 1 is the agreement for sale and power of attorney shall have validity for a period of 1 year from the date of registration. 2, the proprietor of the tea garden shall apply for seeking no objection of the government of Assam through Deputy Commissioner Tinsukia for transfer of the tea garden to the second party of the agreement within 6 months from the date of registration of the agreement for sale. 3, tea land shall be used for tea cultivation and permissible ancillary purposes during the validity of the aforesaid agreement for sale and power of attorney. Or suitable conveyance deed shall be registered within the validity period of 1 year from the date of registration of the proposed agreement for sale and power of attorney. So fixed timelines were given, my lord. Within 1 year, the agreement validity would be 1 year, and within that 1 year, the sale deed has to be registered. Now, my lord,
Agreement for sale and power shall have validity.
shall have a validity of a period of 1 year.
From the date of registration.
And
What is this?
From the date of registration.
Informed government of Assam. Registration of agreement of sale and power of attorney.
So within that 1 year, the sale has to be concluded by execution of a conveyance.
First, the registration of agreement of sale.
First would be the registration of agreement for sale.
And power of attorney.
Yeah, power of attorney. Both of them will have a validity of 1 year. And within that 1 year, the final deed of conveyance, which is at point 4, shall be registered and executed. So essentially, the sale has to be concluded within 1 year from the date of agreement.
The first condition is agreement for sale and power of attorney.
Yes.
Shall have a validity for a period of 1 year from the date of registration.
That's right.
Let us see first this one.
Yes. Now, my lord,
when it was registered?
My lord, the agreement, your lordship finds at page 77, it was done on 16/11/23.
16/11/2023. Yes.
Now, the power of attorney is also of even date. Both of them, it was specifically provided that the validity would be 1 year. Those agreement your lordship finds at page 77 and the POA is at page 127.
The agreement is at?
Page 77.
Yes. PO?
Power of attorney is at page 127.
Yes.
Now, in this power of attorney at page 127, your lordship finds that we had basically handed over all powers to sort of conclude the sale upon the buyer. So the directors of the purchaser company were appointed as attorneys. Now, given this and this attorney at page 128, your lordship finds.
This was registered on 14 August or what?
Yeah, yeah.
14 August?
Yeah.
14 August or what?
16/11, my lord. 16/11.
16/11?
Yes.
16/11. Yes.
And at page 130, it was specified that this power of attorney would remain valid only for a period of 1 year. Now, after this agreements were executed and the power of attorney was executed, certain differences arose between the purchaser and the buyer. Now, we as, the vendor and the buyer, and we as vendors, we filed a suit which your lordship finds at page 163, alleging that they have reached this particular agreement and they've not concluded the sale within the stipulated period of 1 year.
Okay, what is the condition number 4 there?
Condition number 4 is to conclude the sale within 1 year. Page 73.
Yes. 74.
74, the last. And that was also translated in the agreement for sale and power of attorney.
So this title suit was after
expiry of
1 year.
Oh, yes. 1 year expired in 2024, my lord. Then, since they did not conclude the sale, we instituted the suit saying that they've breached the contract and they ought to have registered it within that stipulated period of 1 year. And besides that, we had other allegations that they've encroached upon another division, which was not a subject matter of the sale, etc. All that, of course, may not be relevant at this point of time. So this.
What is the prayer relief for?
8 page 184 onwards. We said pay our balance, give us damages, and
agreement no settlement.
Zonal valuation of tea had also gone down, so therefore the stamp duty registration.
No, where is that prayer?
184.
Non-enforceable.
My lord.
That agreement for sale.
Yes, my lord.
And power of attorney.
Yes.
By expiry of lapse of time has become non-enforceable.
No, we've not said that. We have in fact said that you comply with that term and you pay the money, conclude the sale, and you give us the balance because you're supposed to do it within 1 year. You're not doing it. So therefore, we have said that in the suit, essentially, prayer C, if your lordship sees at page 184, a judgment in decree declaring that the defendant is liable to pay the balance consideration amount of 3.50 crores to the plaintiff company and arrange to get the sale deed executed and registered in its favor within a period of 3 months from the date of institution of the suit, within the period fixed by this honorable court, as the power of attorney provided by the plaintiff company has expired and the entire negotiation sale price of the Schedule A property will become valid. So we did not really want to resile from that agreement. We merely said that the power of attorney had a period of 1 year. You ought to have done it. Please pay your balance and conclude the sale. That was our prayer initially. Then, my lord, we had also made allegations that they were trying to alienate the property again to a different third party, my lord. Besides all of this, we also prayed for recovery of damages, etc., which perhaps may not be relevant at this stage, my lord. Now, my lord, along with this suit, my lord, we had also filed an application for injunction, praying for an ad interim order that they should be restrained from transferring, because by this time we have already handed over possession in terms of the agreement. So they were running the garden. So alongside the suit, we filed an application for injunction to restrain them from creating any third-party rights. That injunction was declined, and against that we came in appeal before this honorable court in the form of an FAO. My lord. That your lordship finds at page 248. Now, what has happened, my lord? This is where the revelation came, my lord. In the course of the hearing, my lord, the counsel for the respondent.
What is the order?
Page 248, it starts, my lord. The injunction was declined, my lord.
In the FAO?
In the FAO also, it said that the trial court should take a decision, but no ad interim orders were passed. But I've annexed this for a particular reason, my lord. Now, if your lordship has to page 256.
Yes.
Now, 256, my lord, during the course of the hearing, a document was placed.
Which paragraph? Which paragraph?
Para 23. Further, on perusal of the letter dated 9/12/2025, issued by the Deputy Commissioner Tinsukia and produced by the Learned Counsel for the respondents today before this court, it appears that the validity of the agreement for sale and power of attorney has been extended by the government until further approval of the government regarding registration of the conveyance deed in respect of Khobong Tea Estate Private Limited. Hence, the only apprehension shown by the present appellant in the injunction praying for grant of an ex parte ad interim temporary injunction does not appear to have any basis. I'm sorry. So basically, we had said that they have already breached the agreement. That term of the agreement is already over. That was also the mandate of the NOC, and that time has expired. Then the respondent produces a document to say that no, it has been extended by the district commissioner. Now, that is when we learn about this impugned order, which your lordship finds at page 258. Now, because your lordship will recall, by the power of attorney, we had vested all powers to the respondent number 6 to pursue with the permission, etc. Now, this order was passed on 9/12/2025, and it says, my lord, the fourth paragraph beginning with however.
The second paragraph, there was another extension.
Yes, second paragraph, there was an extension that was further extended. First of all, it was extended for 6 months without our knowledge. And lastly, it was extended until 11. Now, your lordship will mark the language of the fourth paragraph, my lord. However, as the validity period of the agreement for sale and the power of attorney had lapsed, the entity had applied for an extension of the validity on 8/5/2025, taking into account the fact that the entity has applied for registration of the conveyance deed and the process is presently ongoing. a further extension of the agreement for sale and power of attorney between APJ Tea Limited and Khobong Tea Estate Private Limited is hereby granted until further approval of the government. So what the district commissioner has essentially done, it has entered the realm of private contract, and it has extended the term of the agreement and the power of attorney at the instance of one party. Now, this essentially has a direct bearing on the suit because my entire suit is based on the fact that this agreement has been breached. The time.
Now, what is this order? This order is issued in compliance of Government Office Memorandum because you have entered into agreement.
Yes.
Right?
Yes.
But question of granting this approval having validity of 1 year
Yes.
was by the government.
Yes. Yes.
Not by you.
Not by me.
Not by you two parties.
Yes.
That transfer of property,
yes,
they have granted.
Yes.
For 1 year initially, then extension by application by one party.
Yes. Yes.
Right.
Yes.
Then this second extension.
Yes.
By this government order.
Yes.
Now,
but
what
the
is
extension is of the validity of the agreement and the power of attorney. Because your lordship will appreciate, otherwise I have to apply because of the power of attorney ceases to have any force.
Those conditions were directed to be incorporated by the government by the letter at page 74.
Yes.
Right.
Yes.
That is, as per the instruction of the government, you have incorporated those conditions.
Correct.
Now, thereafter, there was extension.
Yes.
Of that validity period for the agreement for sale of land and plus power of attorney, whatever, by the first extension.
Yes.
Then this is the second extension.
None of which we were aware of.
But the other party has applied.
Now,
maybe by virtue of the power of attorney,
which has otherwise expired. Because the power of attorney was also very clear, only for 1 year.
No, yes, but this was first permission was granted on which year?
74. 23, my lord.
I mean,
5/10/2023.
And when the second extension was granted?
My lord, details we don't have.
11/12/24. Okay. That this is again 9/12/2025.
Yes. So by this time, Lord, he's because otherwise.
Now, what is this government office memorandum?
That is what we find a little absurd because it has the other.
Because maybe he has been delegated with some power.
My lord.
Page 258.
Yes, my lord.
This order is issued in compliance with government.
The order dated.
Yes.
OM dated 5/12/2023.
And this extension is granted.
Yes.
Until further approval of the government regarding registration of the conveyance deed in respect of so and so.
Yes.
So by this order,
yes,
he has extended the
not just his own approval, but he has also extended the validity of the agreement and the power of attorney which had expired by then. Because he cannot take into account that prayer for extension, but for the power of attorney. But the power of attorney is very clear. It says 1 year. So therefore, after expiry of 1 year,
what is this government memorandum?
That perhaps your lordship has to call for.
Because that will have some significance.
Yes. Now, there is more to the.
This is 5/12/2023. Is it not available in the public domain?
We attempted.
Yes, Mr. Das. Can you place this office memorandum?
That I'll have to take instruction, my lord, whether it is.
What instruction?
No,
If there is existence of a government memorandum, then
No,
there is no question of taking instruction. You have to produce it. That's all. You have exercised some power.
Yes, my lord. I'll
under some office memorandum.
I'll produce
You
that, my lord.
place it.
It also says, my lord, whereas the government had extension, it might be, my lord, the power of attorney and agreement for sale is still in existence, my lord, but it says registered instrument. That also will have to be taken into.
No, whether this
registered
validity
instrument
can be
have to be cancelled.
extended. Validity can be extended.
My lord,
without
I think validity is regard to most probably what I understand, my lord, regard to be sale permission, my lord, not for the, my lord, this.
That is not clearly appearing from
the language shows something else.
The agreement for sale.
Sale permission to extend koribo pare kintu.
Permission?
Yes, that is what I'm not
Yes,
very
I
clear from.
understand, my lord. They can extend the permission, my lord.
But if they enter into the recitals of the agreement for sale or
Power of
that thing will examine. But what he has actually
The language
extended, because he
proves-
said until further approval of the government regarding registration of the conveyance. At the same time, he is making this.
No, my lord, if I may just place the subsequent
Para 4, my lord.
Yes, please.
Now, after we came to know from this High Court proceeding that such a extension has been made, we wrote to the sub-registrar that you do not register any particular deed. Now, page 265, your lordship will find this extension of the power of attorney was necessary because of page 265. 265, my lord, they registered the conveyance deed. Now, when they registered the conveyance deed, I, that is APJ, is shown represented by the office bearers of Khobong by virtue of the power of attorney, and the reference has been made to the power of attorney. Page 265. Now, this again violates Registration Act now.
Why?
My lord, we'll have the Registration Act for a moment.
Tell me. Otherwise.
My lord, basically, my lord, who is going to present the document for registration? It could be either me, APJ, or it could be my authorized representative. Now, he claims to be the authorized representative on the basis of that old power of attorney which has expired. So, therefore, he relies on that particular impugned order of 9/5/2025 saying the district commissioner has perhaps extended my authority under the power of attorney which has otherwise expired, so I can present it for registration as an authorized. We can only assume, my lord, because here he is shown to be represented by the buyer again.
Come to 258 again.
258. Yes.
Paragraph 2.
Yes, madam.
Please read.
Whereas the government had again given an extension, while letter number so and so dated 11/12/24 for sale for a period of 6 months, which validity expired on 11/6/25. In the same government approval, it was stipulated that the entity must apply for registration of the conveyance deed within a period of 6 months, which they have complied with.
What does it mean? Conveyance deed means sale deed?
Sell it.
Yes, a conveyance deed means
within a period of 6 months,
Yes.
which
they
had complied with.
They have
Meaning thereby
through my attorney.
that sale deed was placed for registration.
Yes. No, my lord, in the same, my lord, will recall point number 3, which said that you must also apply for sale permission for the conveyance deed at page 77 again for a moment. 74, I'm sorry. Number 2.
Where is the other letter? 11/2/2024.
My lord, that we don't. 11/12, my lord. 11/12. My
11/12.
lord, we had no clue until this was produced in the proceedings. Lordship has to call for the.
Now there it is mentioned which they have duly complied with.
Yes.
The conveyance took place on 31st of December 25. But this is a order, my lord, 9 December 2025.
31st?
31st, 12, 2025. Now the word says they have duly complied with. My lord, but its order shows 9 December. How can be duly complied with?
Must apply for registration of the conveyance deed.
Acha.
Not registration.
Yes.
Application for registration.
Application for registration.
Application for registration, then the next event will be registration.
And that was done within 6 months. My lord.
Extension of validity. Registration of the conveyance deed. So during the first extension, they have applied for registration of a conveyance deed.
Yes, yes.
Then, last but one paragraph.
Yes.
He says, taking into account the fact that the entity has applied for registration of the conveyance deed.
Yes.
And the process is presently undergoing.
Yes.
A further extension of the agreement for sale.
And the power of attorney.
Is hereby granted. Until further approval of the government regarding registration of the conveyance deed in respect of one. Further approval for registration of conveyance deed. But here he has extended agreement for sale and power of attorney.
Power of attorney. Now, because he has extended.
And this is issued in compliance with government office.
OM, my lord, if found, it is just delegation of powers, my lord.
Maybe.
Yes.
It looks like delegation of powers.
Just delegation of powers. Now, my lord, what I'm trying to hinge on this, my lord, if this, although approval or permissions could have been extended, he could not have extended power of attorney, which is a private contract of agency, my lord. Now, because he has extended validity of the power of attorney, that gave them a power to approach the sub-registrar in my absence on the strength of the expired power of attorney and to place it for registration without I'm there, without me being even present.
Then thereafter registration has been done.
Yes. Page 265. Now, my lord.
Now, this registration is subject matter of the trials.
No, it is not yet because, well, Lord, I can understand those but
this-
here we are challenging
has
the
to
state
be-
action. Because it's state,
Right. This otherwise this registration of the sale deed is will be subject matter of the civil court.
My lord, the registration part of it.
Subject to the validity of this order.
Correct.
Right.
Correct. Yes.
Otherwise, we are not going to enter into the dispute regarding
No,
this
I will
registration.
not urge your lordship.
But so far as this order, what is the you place this? Do you have that office memorandum?
Office memorandum. Yes.
Send it to by email.
Understood.
For my lord,
Yes.
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 Now, my lord, if your lordship has the registration act for a moment.
Yes.
My lord, that's why I say, my lord, it's a statutory violation. Now, section 32. The part concerning presentation of documents for registration, you know.
Yes.
Now, 32, persons to present documents for registration. Except in the cases mentioned under 31, 88, and 89, every document to be registered under this Act, whether such registration be compulsory or optional, shall be presented at the proper office, A, by some person executing or claiming under the same, or in the case of a decree or order, claiming under the decree or order. So I would have ideally fell under clause A, my lord. B, representative or assign of such a person, my lord. None of my representatives were present, my lord. C says, by the agent of such a person, representative or assign, duly authorized by power of attorney, executed and authenticated in the manner hereinafter mentioned. So they probably presented it on the strength of 32 C, my lord. Now, my lord, after it is presented, section 34, if your lordship has,
Yes.
subject to the provision, inquiry before the before registration by registering officer. Subject to the provisions contained in this part and in sections 41, 43, 45, 69, 75, 77, 88, and 89, no document shall be registered under this Act unless the person executing such document or the representative assigns or agents authorized as aforesaid appear before the registering officer within the time allowed for presentation under section 23, 24, 25, and 26. Provided that if owing to urgent necessity or unavoidable accident, all such persons do not so appear, the registrar in cases where the delay in appearing does not exceed 4 months may direct that on payment of fine not exceeding 10 times the amount, the proper registration fee in addition to the fine, if any, payable under 25, the document may be registered. Appearances under subsection 1 may be simultaneous or at different times. 3 is important. The registering officer shall thereupon inquire whether or not document was executed by the person by whom it purports to have been executed, satisfy himself as to the identity of the persons appearing before him and alleging that they have executed the document, and C, in the case of any person appearing as a representative, a sign or agent, satisfy himself of the right of such person so to appear. Now, my lord, in a regular circumstance, my lord, one who approaches with a power of attorney, the inquiry, there are Supreme Court judgments also to that effect, the registering authority will inquire whether he has adequate powers or not, which the sub-registrar, if it would have been done in the case at hand, my lord, would have realized the power of attorney on the basis of which he is placing it for registration has otherwise expired. Now that inquiry was either skipped or that inquiry was sort of influenced by the fact that the district commissioner has extended the validity of the power of attorney, which in my respectful submission could not have been done. Only I could have extended the power of attorney.
Come to 270.
Yes.
Up below the table.
Yes, my lord.
Third paragraph.
Yes. Whether the third paragraph, whether for this transaction of sale, the district commissioner pursuant to the so-and-so has granted NOC permission dated 15/12/2025 for the scheduled land by the vendor in favor of the purchaser, which shall remain for valid for a period of 6 months. Said NOC.
There are many other letters.
Yes. Yes.
There are many other letters.
Also bears the
It is not only this 258.
Yes.
This is 9/12/2025.
Yes.
Right. Thereafter, another letter, District Commissioner 10/12/2025.
50.
NOC self-permission.
Yes. Now,
right.
all of this is.
Then, government letter, again 10/12/2025. One more government letter.
Yes.
Then District Commissioner, self-permission, 15/12/2025. These are mentioned.
Yes.
So far as these provisions, he got satisfied with the government letter and all.
Yes.
Maybe.
Yes. Yes. Yes.
At the time of registration, which you have referred to section 34.
Yes.
32 read with 34.
Yes. Yes.
He may have privacy satisfied with the government letter.
Yes.
By the provisions of 114.
Yes. Yes.
Government order passed are deemed to be duly passed.
Yes. Yes.
Right.
Yes.
That 34 may be, may not come into picture, but subject to further examination. What is this?
This is the
to allow registration for authority in case of in case of change of management.
This is in term 74 is also probably a replication of this notification only.
So if the power of attorney, you have granted a power of attorney, if that is valid,
then he could have.
and the power of attorney holder makes an application for extension, it would be on your behalf.
Yes. Yes.
If it was valid.
Yes. 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 The entire exercise would do it because your lordship will appreciate the injury that is likely to be. He doesn't.
I am considering that for that purpose only I am trying to find out.
Yes. 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 So I was
And
just-
but it is also not very much believable that the earlier extension you were not
aware of.
Yes.
Yes.
One extension, it is not that it is a second extension.
Yes. Yes.
During which this registration
Yes.
has been extended, for this thing has been extended. There was an earlier extension.
That also beyond the validity.
Right. And everything is in the suit.
Yes.
And the second, this registration agreement is different. But in between, this order has come.
Yes. Yes.
This order, we are examining the legality and validity of this order.
Yes.
But by way of an notification, the delegation of power has been extended.
Yes.
Regarding, it is limited to registration of agreement of sale and power of attorney.
Yes.
Not this thing. Approval to the registration of conveyance deed. This is something, all these are a bit tricky.
Yes. Now, so basically, without my concurrence, my lord, they have gone ahead by acting, posing as an agent, notwithstanding the expiry of the power of attorney, and those actions.
If the power of attorney is valid,
yes,
then registration of the agreement can be valid.
But
That is subject matter of civil suit.
Yes. But the power of attorney is very clear, 1 year. And it could have been extended mutually, my lord, but the deputy district commissioner.
So what relief you are seeking here?
My lord, we want this particular, because ultimately they'll steal a march in the suit. They'll say that we've already registered the sale deed, regardless of the fact that they've paid balance consideration, etc. So, since the action of the state, my lord, it had that order of 9-5 and the consequential action of registering the conveyance deed. In fact, we brought it to the notice of the sub-registrar that such a suit is pending. Kindly do not act on this. And they registered it on the very next day. And in that conveyance deed also, they make a reference only to.
Okay, we'll proceed again.
Yeah.
Right. I have something urgent.
Yes, yes, my lord.
So, Deka, what is the source of power for the government? Otherwise, to
accord permission, right? That would perhaps be 21A of the Registration Act, with the state amendment.
okay. Today you are seeking what order?
Lord, we have an interim prayer staying the effect of the deed of.
Then it will be, everything will be in disarray. Subsequent registration of sale will be also in disarray.
Yes,
Is it
because based on this, perhaps now they'll obtain mutation, etc. So therefore, we were.
Okay. Okay, let us have it with more time.
Manoj.
On Thursday?
Manoj.
Yes, let me go through it. There will be many.
Meanwhile, I'll try to procure those orders if they're
Yes,
ready.
yes. Heard Mr. B.D. Deka, Council for the Petitioner, post of Mr. H. Sharma.
Endas
Huh?
he has left because some personal difficulty.
Okay, Mr. Endas. No, I will record the presence only. Release the case again on Thursday.
7th or 8th, no? 7th.
8, 8 will be difficult. 7th. 7th? You have any problem?
I have a couple of matters fixed, so therefore one.
Okay. It will be in the motion stage. Or otherwise, Monday.
Monday. 11th.
Okay. 11/5. Miss Anne Borolo. Standing House Revenue Department. And Mr. Andas, Junior Government Advocate for the state respondents are present.
No, can they be directed to produce the other letters, Madam?
Which one? Yes, which one?
The sale, the ones which have been reflected in the deed of conveyance, which your lordship had.
Yes, yes.
Page 270.
Okay, 270. Okay. The Mr. It will be Revenue Department letter.
Yes.
The respondents shall make endeavor to produce a copy each of the government letter number, page 270. E-37783/2025, dated 10/12/2025, and no objection certificate sale permission bearing number TLSP.5 T dot capital T dot P dot 2025, dated 15/12/2025, comma, as reflected in the
deed of conveyance.
Deed of conveyance registered on
31/12,
12/2025.
registered on 1/1/26.
31/12/2025.
Registered on 1/1/26.
A deed of conveyance dated 31/12/2025 and registered on
1/1/26.
1/1/2026. 1/1/2026. Page 270, Mr. Sharma.
Lordship.
Third paragraph below the table.
Yes.
Right?
Obliged.
On 11th, Lordship.
11.
Item 18.
May it please your lordship. Lordship, very briefly, the grievance of the petitioner is that despite having the requisite ownership over the land, the patta was still not been issued, your lordship, in the name of the petitioner.
Seeking regular patta.
Your Lordship.
Where is the Sita certificate?
Your Lordship, the original tenant had their names in
No,
the
you said
Khatiyar.
in your synopsis
Lordship.
that the same was recorded in Sita certificate. Your name.
Your Lordship, it's only a typing error in the synopsis, Your Lordship. In the main petition, it is not been.
Defined case that's in the Sita certificate, your name has been registered.
Lordship, it's a small typing error. So, Lordship,
We go by the synopsis normally.
Lordship, I apologize, Lordship. The main petition, we have attested the deed dated two deeds, Your Lordship. The original tenant had sold the land to one person at first in 1997, and then further it was
Seeking issuance had Mr.
I.S. Mazharpuria, Your Lordship.
Learned Counsel for the petitioner. Ms. N. Bordole, Standing Counsel, Revenue Department for the respondent number 1, Mr. H. Sharma.
2 and 3.
Additional Senior Government Advocate for the respondent number 2 and 3. First of seeking issuance of seeking direction to the respondent authorities to issue regular patta to the petitioner in respect of a plot of land, comma, covered by DAG number 128 within bracket old, stroke 145 within bracket new, comma, situated at village Baniapara, Bilashipara Revenue Circle, District Dhubri. In terms of the provisions of the Assam land holding within bracket adoption of relationship under the Assam Land and Revenue Regulation, 1886, in the acquired permanently settled estates, bracket close, Act 1974, on the strength of a sale deed and by virtue of long possession, the petitioner has preferred the present petition, issue notice returnable on so and so, as Ms. Bordolo and Mr. Sharma. No formal notice, extra copy during working days.
Lordship, if I may. Lordship, in a similarly situated case, an interim order had been allowed, Your Lordship.
What similarly?
We have annexed it in Annexure 7, page 30 and 32.
You projected your case wrongly. Okay, having regard to the projection made as regards the petitioner's long possession, it is provided that till the next date is the returnable date, the party shall maintain status quo as existing today in respect of the plot of land referred herein above.
10 June. Item number 20.
My lord, SBI, Borpeta Road branch, my lord. And the legal.
Similar order. Page 13. Oh, sorry, item number 13.
Yes, similar.
Okay, item number 13 order silo. Amount to Borpeta Road branch, Borpeta, State Bank of India, account number and amount disputed transaction. Same order, huh? Item number 13. Same date, returnable.
Item 21.
May I please your lordship? Your lordship, the present rate is filed.
Let me just a minute. Yes.
Your Lordship, the present writ is filed against the coercive action taken by lots of coercive action taken by the GST
Let us
department.
see first your case.
My case is Your Lordship, that the goods were seized during the search and seizure
When?
exercise in the month of May, 21st of May 2025.
21st of May, which let us see. Take us to the documents.
INS2 is INS1 and 2 is attached for number 46 and 47.
Page number
46.
46.
Yes.
This is on 21/5/2025.
And thereafter.
What? This is search warrant.
Search warrants. And thereafter on 48.
Search warrant. Okay. Then
thereafter on page
seizure.
48, seizure.
Seizure was made. Then Panchnama was drawn. Then what is this order? Page 52.
52 order is this is summon.
Direction to produce.
Summon. Summon issued after
Documents.
Search and seizure, yes.
Yes. What are the documents? No
Documents.
case. Page 54. Invoices. Okay.
Invoice. All the
These are the
documents
list.
related.
Page 55 is the list.
55 is the annexure of summon.
Thereafter, what happened?
Thereafter,
After the summon?
After summon on 31st of May, we submitted.
Annexure E.
Annexure E. We submitted the authorization and related documents. Total of comprising total of 1327 pages.
Documents in response to summon under section 70. Okay. Immediate affair. Received here time. Okay, page 66 to submit time, seeking time to produce remaining documents.
We have submitted 1327
Page
pages.
66 is an application seeking extension of time to furnish the remaining documents.
No, Your Lordship.
We have to page 67, sir. Read the paragraph, second paragraph.
It is respectfully requested that the documents now submitted may kindly be received, acknowledged, and taken on record for preliminary scrutiny, while reasonable time and indulgence be extended for submission of the remaining documents.
Why you are no, you are saying? Yes. Why you are saying no?
No, Your Lordship. Actually, the pages were submitted, they have inquired for, and for one thing.
This is an application seeking extension of time to submit the remaining documents. Nothing else than that.
We have submitted.
Page 66.
Yes, Your Lordship.
Don't say no.
I was.
Page 68 is the documents you have submitted.
Submitted, yes, Your Lordship.
Now what is 69?
69 is the matter where they have issued the summon on 28th of May. In that particular details, the matter of Leeladhari Nayak was included, which was already pending appeal. So we requested to exclude the matter from the inquiry.
Then what happened?
Thereafter, they have excluded.
Issued show cause notice.
Thereafter, show cause notice was
74 under section 74.
Under 74.
Okay.
And the order was issued on 31st of December 2025.
Order was issued.
Yes.
Which is the order?
Order is, Your Lordship, at 76. Page number 76, Your Lordship.
76. 31, 12. So liability was mentioned in page 79. And you were directed to make the payment by 31st January 2026.
Yes, Lord.
Right? Summary of the order. Then what is this 74A?
74.
Same date.
They are same thing, but for the period, the sections were different. So they have ordered in different pages.
This 74A.
Yes, your lordship.
20 financial year 2021 to 26. Order under you prefer a writ petition.
You prefer a writ petition.
Right.
In between.
Wherein you have assailed suspension of GST registration, revocation of the revocation of the attachment of bank account, restraining the respondent authorities from adjudicating the demand, and return all documents. Then in the meantime, those orders have been passed.
Yes, your lordship.
Right? 31/12/2025. 25.
Yes, sir.
Now come and read paragraph 8 of the order, 168.
68. Ever had the non-counsel of the parties, and upon reversal of reading of record, this court is to view that the writ petition was filed putting the challenge the process undertaken by the respondent for suspension of GST registration, the attachment of bank account, and raising any demands in terms of the proceeding which were undertaken, and also to return the documents and materials seized unlawful according to the petitioner, and further to quash the proceeding under INS 01 issued on 21st May 2025 during the pendency of this petition, since the final order have already been passed under section 74/74A of the CGST Act, and there are adequate appellate provision prescribed in the statute, and the questions of the legality of the procedure undertaken by the respondent authorities, which is assailed in the present writ petition according to this court, will not serve the useful purpose, as in the meantime the respondent authorities have concluded the proceeding and have passed order on 31st/12/2025. Which order as on date the petitioner has not assailed till date. As admitted by the learned counsel for the petitioner, there is no specific challenge to the interim order either in present writ petition or in any other proceeding before this court.
Then paragraph 10.
The dismissal of the writ petition, however, will not curtail the right of the petitioner to assail the order passed by the respondent authorities pursuant to the summons.
What is the meaning of this order? As on that the petitioner has not assailed till date. That is by appeal.
That is by appeal.
Have you preferred any appeal?
We have been planning for that, but
all these have been subsumed in all these prayers. If you read paragraph 8, Everything is clear.
Yes, Your Lordship, but here we are here for a matter which is regarding the seizure of goods. And
That is there already.
And for that
Let us see your first paragraph then. First paragraph.
first paragraph of 167, sir.
165. First paragraph. What are the directions sought for? Challenge was to revocation or the suspension of the GST registration.
Yes, Your
For revocation of the attachment of the bank account.
Yes, Your Lordship.
For restraining the respondent authorities for adjudicating the demand, which has already been finalized. And for return to all documents, including inventories, materials seized unlawfully, and to quash the proceeding of INS.
Yes.
Now all these are subject matter of challenge in an appeal.
Appeal. But
that has been duly noted by the
yes, Your
defense.
Lordship. Yes, Your Lordship. We had proceeded for the appeal.
So have you preferred any appeal?
That's why
when it is an order for which a statutory appeal is available. Let us see the prayer.
And
A. Return all goods, document inventories. B. Revocation of suspension, GST registration.
Yes, Your Lordship.
C. Revocation of provisional attachment under section 83. D. Enter file, return of enter file. Oh, sorry, to write the husband to place on record the enter file. This is within the province of appeal.
Yes, Your Lordship.
E. Re-agitating and including demands already adjudicated. What is that? Then F. Quash and set aside INS 01.
Yes, Your Lordship.
Dated 21/5/2025, which also
is matter
has
of appeal.
Reached a finality by that order, which is an appealable order.
Yes, Your Lordship.
Z. This is also subject matter of appeal.
Yes, Your Lordship.
Then H. Instead of the respondent, it should be the petitioner. Why filing this
It is
writ petition?
Yes.
The writ petitioner has invited for cost.
No, Your Lordship.
This is, have you prepared any appeals?
That's why we are here, Your Lordship.
Why not?
Because the appeal says
when a statutory appeal is available.
Yes, Your Lordship.
Just to obviate the deposit of the amount.
Yes, Your Lordship.
We are not entertaining this repeat.
No, we are not here about
absolutely nothing.
We are not here for amount, Your Lordship. We are here for the continued seizure of the goods.
File an application as an IA in the appeal.
Lordship, page 184, they have preferred the statutory appeal only on 14th of April 2026.
No, Your Lordship, that's all.
Page 184.
See, coordinate bench has already observed. Paragraph 8.
Your Lordship.
And just because or is there in paragraph 6, that does not give you license.
But my
to prefer. Yes, Mr. Counsel, come to page, paragraph 8, page 169. That no specific challenge to the impugn order either in a writ petition or any other proceeding before this court. But before that, court has already observed that this is adequate appellate provisions prescribed in the statute.
No, what brings us
if you are aggrieved by this order, otherwise this is request closure of the writ petition is right at this moment.
We agree with the order of the court, apex court.
Go and prefer appeal. But you have already preferred.
But my humble submission here, Your Lordship, is that the goods which was seized on
file an IA in that appeal.
No, Your Lordship.
Why multiplicity of proceeding?
Because
court has already observed.
We have three.
Mr. Counsel, paragraph 8. 4th line. Also to return the documents and inventories materials seized unlawfully, according to the petitioner. Right? File an IA in the appeal, the appellate court forum will have all the jurisdiction.
But your
because
lordship,
it will be in continuation of the original order.
they are not revoking the seizure which have already
The
passed
Mr.
the
Counsel,
extent.
paragraph 8, it has clearly, otherwise we prefer appeal against this order.
We are there, but due to the seizure and bank attachment and
Mr. Counsel, it is already all these prayers were made in the earlier round of writ petition.
Yes, good.
Court has closed, saying that adequate appellate provisions in the statute and all these proceedings have attained finality by way of an order dated that has been quoted. The entire order has been quoted
But
in order.
your lordship, my humble submission is just about the section 67 of the GST Act, which made
It's all these are now after that order,
yes, your lordship.
and by virtue of the order of the coordinate bench.
No, but the seizure was automatically the seizure must have been automatically revoked after the final order they have made
The
on
appellate
31st.
order,
No, 31st of
the
December.
appellate forum
Yes, your lord.
has all the jurisdiction to decide on the order dated
But it cannot be-
31/12
but
and
it-
plus. It has jurisdiction to pass interim orders
Yes, your lordship.
regarding your alleged unlawful retention of documents. So by way of an interim order, you can
But the
seek an application.
but the present situation is that we have filed the appeal.
Where is your appeal?
No, but the same is
Where is your appeal?
appeal is
Where is your statement that you have
no, that-
preferred an
that-
appeal?
That's pending because of pre-deposit, which
That I could
no, no.
understand.
No, your lordship.
Then
My humble
third.
my humble submission is that the goods which was seized.
That is everything coordinate bench has already observed. I cannot review that order.
But we have
This is not a review petition. Court has already observed.
we have submitted lots of submissions regarding release of.
But that has the entire proceeding during the pendency of the writ petition, an order has been passed under section 74 and 74A on 31/12/2025. And the coordinate bench has already observed that with the passing of the order and with no challenge
Sure.
to the order by way of an appeal for which there is adequate provision in the statute. So we are not what the court has observed.
The court
Tell
has-
me.
The court has.
What the court will not serve any useful purpose.
Yes, sir.
So, as in the meantime, have concluded the proceeding, have passed the final orders. So, Paratin will not curtail the right of the petition to assail the order passed by the respondent authorities pursuant to the summons issued by the order dated 31/12/2025. So, this order is to be appealed.
But after
As simple as that.
but after-
Wherein all interim prayers as regards what you had asked for in the writ petition can be made.
Your lordship, after the final order they have made on 31/12/2025, the seized goods and documents must have been released, which they have not released by the.
Please ask before the
We
appellate
have-
forum.
We have submitted.
Please ask before the appellate forum.
We have.
Again, shall I revert back to paragraph 2
No, no, your
of the order? 27/1/2026. Come to page 165. And paragraph 8, which seizure was unlawful according to the petitioner. That's the court has recorded.
Yes, your lordship.
According to the petitioner, court has not recorded that it is unlawful.
But we are not here for the seizure. We are here for the continuance of seizure after the conclusion of the inquiry.
No, all these prayers were made in the earlier round of writ petition.
But that was
And
before the.
I have one by one from A to the end.
Yes,
I
Your
have
Lordship.
taken you to the prayer,
Yes, your lordship.
which are already made in the earlier writ
Yes,
petition.
your lordship.
Yes,
But-
mister.
But that was prior
It
to.
entails dismissal in limine.
Yes. But your lordship, may I submit the section which made the search and seizure possible?
No, it is not to be revisited before this court regarding LAs and everything. already it has attained finality by way of that order, it has to be challenged. And that order is subject matter of challenge in an appeal. And all the proceedings would be relooked in the appeal by the appellate forum. If it finds it unlawful, as claimed by the petitioner, it will be set aside.
But your lordship, the business is
Just because of the pre-deposit, you are trying. No, that is the only intention.
no the paralyzing the business is the matter, your lordship.
Go and file before I ask for an interim order there. This is not the way.
But your lordship, this
Heard, Mr.
take it.
Take a jar. This is abuse of the process of the court. Learned counsel for the petitioner. Yes, Mr. Chaudhary. Where is that appeal preferred?
Lordship, page 184.
Mr. Jha, what cannot be done directly cannot be done indirectly.
No, your lordship.
Oh, what is the order? Okay, 184. Appeal.
This was of
Order was-
Leeladhari Nayak, the matter for which the letter was submitted on 10th of June regarding inclusion of Leeladhari Nayak.
Order
in the
replied to the show cause notice is 9-4. And Mr. B. Chaudhary, Learned Standing Counsel, Finance and Taxation Department for Assam for all the respondents. So the petitioner has instituted the instant writ petition under Article 226 of the Constitution of India, seeking the following relief. Paragraph. Page 36, A, B, C, D, E, F, Z, H, I. Para. The petitioner had preferred a writ petition earlier. Preferred a writ petition WPC number 3576, 2025 earlier. And during the pendency of the writ petition, the order, an order under section 74 of the AGST Act,
Yes, AGST.
was passed on 31/12/2025. And also an order under order of event date under section 74A of the AGST Act. Full stop. It was during the pendency of the writ petition WPC number so and so. The orders dated 31/12/2025 were passed. Full stop. Para taking note of the orders dated 31/12/2025, the writ petition WPC number 3576/2025 was dismissed with the following observations. Page 168, para 7, 8, 9, and 10. Para. From annexer A to the writ petition, it is found that the petitioner has already preferred an appeal against the orders mentioned above, before the appellate authority.
Your lordship, may I The appeal was of the earlier order which was issued in
Okay.
in the month of February 25.
On a query, the petitioner, learned counsel for the petitioner submitted that no appeal as on date has been preferred
Appeal has
against
been
the
filed
orders.
but not accepted till late because of the pre-deposit procedure and verification.
So it is no appeal in the eye of law. No appeal as required under the provisions of the AGXT Act has been preferred before the appellate authority. It is no appeal in the eye of law.
In our form, it is filed, but the pending part of on the department for their acceptance.
Is there any provision for exemption of the pre-deposit?
Not fully, Your Lordship.
And an appeal without pre-deposit is an appeal in the eye of law.
No, it's on their discretion.
Okay, the learned counsel for the petitioner has submitted that. Though an appeal has been preferred against the orders dated 31/12/2025, the appeal has been filed without the requisite pre-deposit as prescribed by the AGST Act 2017. Full stop. Having regard to the prayers made in this relief sought for in the writ petition, and the order and the purport of the order dated 21/7/2026, passed in WBC number 3576/2025, this court is of the considered view that the writ petition was dismissed on 27/1/2026, reserving the liberty of the petitioner to assail the orders dated 31/12/2025 by way of an appeal, wherein all the reliefs sought for in this writ petition would be available to the petitioner to be agitated before the appellate forum. In such view of the matter, this court does not find any reason to entertain the instant writ petition. The writ petition, resulting the writ petition is dismissed. Okay.
22. Item number 22.
It's 21, my lord, they are unable to get their name registered. Third round of litigation. My lord, if your lordship looks into section 3A, I'll be praying for only notice.
Heard Mr. B.D. Das, senior counsel, is by Ms. R. Deka, learned counsel for the petitioner. And Mr. H. Sharma.
2, 4, and 5.
Learned additional senior government advocate for the respondent number 2,
4, and 5.
4, and 5. This register has a standing counsel. One case, Mr. Jero appeared. I don't know. Similar issue, dispute about the name. Mr. Jero
We
appeared.
applied earlier.
No, for
Yes.
Jero assisted by his counsel, I don't know. Anyway, the petitioner is aggrieved by
Steps against respondent.
the petitioner is aggrieved by non-registration. Aggrieved by its non-registration of its application under section 3 of the Societies Registration Act 1860 by the respondent number 3. Full stop. Any denial order?
Denial order is their last order. Man.
Okay.
Page 44.
By an order dated 8/12/2025, the respondent number 3 has denied registration on the ground that the petitioner has an identical name with another registered society.
6.
That is the response number 6. Issue notice returnable on so-and-so. As Mr. Sharma. 1,
2, 4, and 5.
2, and 4.
2, 4,
Extra
5.
copies, 2 working days. The petitioner shall take steps upon the steps for service of notice upon the respondent number 1. Oh, what? Not 1. 1 you are accepting.
No, Lordship is a Fishery Department, Lordship.
Farm and
It is
Society.
a government department.
Farm and Society Department.
Is there any department?
Lordship.
They can take.
Is there any department like this? I have not heard. I have not heard.
Secretary, Farm and Society is there, my lord.
Huh?
Commissioner and Secretary, Farm and Societies Department.
Is there anything like that?
Facility.
I don't think. I don't think.
They were parties in earlier case laws.
Is it? Okay. Yes, you can accept an immediate government 1. Sharma is also 1. 3 and 6 by speed post within 3 working days from today.
10-0.
Find out is there any department? So as on date it is Farm and Societies Department.
10 June.
Hello, it's take steps by registered.
Speed post.
Yes.
Nowadays it is speed post.
23.
May I plead the Lordship?
Account.
Yes, Lordship.
It will look. 13 on is same. Not 13 on is now. Or 13 on is same like 13, huh? ইয়াতে account number লিখা আছে, bank branch লিখা আছে, this period amount 1700 লিখা আছে. Same like 13.
Item 24.
May I please?
Yes, Mr. Das.
Lordship, against the rejection of settlement application, that is.
Rejection?
Yes, my lord. Petitioner had applied for settlement of government cost and selling surplus land of 1 kata.
When?
It is Bosundra 220. Kindly find that application at page 25. Page 25, Annexure 6. Thereafter, rejection order is at page 26. It is rejected by the circle officer saying that on the field inquiry.
This is otherwise an appellate order.
My lord.
Appealable order.
Because
this is an
a
appealable
similar
order.
case
This
is also
under
pending.
Right to Public Services Act. Come to page 25.
Yes, my lord.
You may raise an appeal. And also against an order. This is under Right to Public Services Act.
A similar case is pending also before this.
No, but when the state appeal is available, why will entertain this petition? Yes, Ms. Bordoloi. Whether an appeal is appellate provision is with power to condone delay.
Delay point, your lordship, that
I think this is an appellable order.
lordship regarding as far as my confirmation regarding allotment and settlement, your lordship, Bosundra application rejection, those types of cases.
Whether this comes under Right to Public Services Act or not.
Yes.
If it comes, then any order of rejection is an appealable order.
Appealable order.
Appellate forum is there.
But your lordship, as far as I inquired, your lordship, regarding allotment and settlement, the person has to reapply if it is under Bosundra scheme.
Shows the provision.
That I'll have to see.
Then if you that power to reapply, right to reapply is there, then he will apply removing the allegation or justifying the allegation that land is found to have been encroached in recent years in organized basis is therefore excluded from the purview of Mission Bosundra.
Yes.
Yes, what does it mean, Mr. Sharma?
Organized.
Organized based,
basis.
Encroached in recent years.
recent
In
years.
organized basis.
But
So, according to them, Lordship, most probably the lands are encroached recently.
In recent years.
In a organized way.
Recent years means multiple years.
Multiple years.
In organized basis, is therefore excluded from the purview of Mission Bosundra. Why?
But I have to.
See, madam, if is because it was rejected in 2023.
yes, ma'am.
So more than 2.5 years, almost. About 2.5 years.
Deliver.
So if you have a right to reapply, find out, then we'll give him liberty to reapply. Otherwise, you have waited for 2.5 years.
Yes.
And you can make the application with a justification that why. Or is it an appealable order? Both will find out if an appealable order and power to condone delay, we can ask him to file an appeal.
Now the Bosundra 3 is going on, Lordship. We can very well apply.
Get the application, get the this scheme, Bosundra 30. We'll ask him to file application. Thereafter rejection, you file appeal in proper time. But give the scheme. Day after tomorrow. Okay. And Mr. Siras, just the scheme. It might be available in the online. Or Mr. Das, you have the scheme, new scheme.
I don't have my lord.
Okay. Miss N. Bordoloi, learned standing counsel, SC Das, for the petition. N. Bordoloi, standing counsel, Revenue Department for the response number 1 and 2. And Mr. D. H. Sharma, learned additional senior government advocate for the response number 3 and 4. Full stop. The learned counsel for the respondents have submitted that even after rejection of the petitioner's application for settlement of khas and ceiling surplus land under Mission Bosundra 2.0, it is still available for the petitioner for making another application under Mission Bosundra 3.0, which scheme is presently undergoing. To supplement such submission, Ms. Bordoloi has sought listing of the case on Wednesday in order to.
Can it be 8, my lord? I would be.
Monday. 11/5/2026, in order to make an endeavor to produce the scheme of Mission Bosundra 3.0. So list the case accordingly on 11/05/2026.
Supplementary list, item 46.
And then submit we have the paying a land revenue in respect of any position since many years. In this respect will be apparent from so and so. Taking into account and that enclose any document which because the land is the opinion of this query.
Second thing.
My submission is very much limited.
Whether you became the owner by way of inheritance, or by purchase, or by allotment.
Self-acquired property, that much is
Self-acquired. By Dokoli.
That exact information I have not.
Either by inheritance or by purchase. Self-acquired can only be by purchase. Under the law. And beyond the law, in different manner, it can be self-acquired, which we are not going into. So, the coordinate bench has declined that you have failed to meet the threshold.
That I have filed.
So, justify.
That
justify.
Affidavit I have shown the.
Revenue receipt already examined.
Here, what happened, my lord? The report is very much clear that
File whether what is that concept in civil law? That occupation for 12 years. What is that called?
Adverse position.
Against government can be claimed.
No.
No, that option is also not available.
This is not government land, let me read the patta land.
Huh?
It is patta land.
Oh, then?
It is a patta land and I am paying.
Patta land?
Yes.
And self-acquired, how can it be possible?
Patta land.
Then it is a case of adverse possession.
It is a patta land.
Whose names are reflected?
My submission is that as per report, the person to name is appeared, they have no existence in the.
Mr. Inauddin, the Korean bench has already observed the tentative view of the court. So you have to overcome that.
My case is there. The name appeared are fictitious, my lord. Because the report I have annexed.
We don't know it is in the record.
So
where is that revenue record? Where their names are appearing?
Your lordship.
Please take us.
Page 16, your lordship will find.
Page 16. Page 16.
This is revenue clearance report. Receipt.
So the revenue Jamabandi and Cheetah.
Jamabandi, this name are there. These
names are there.
Therefore.
So that is record of right.
Yeah.
Now, so
in page 18.
Cheetah.
Cheetah have not annexed because it is an admitted fact. In their name is there in the cheat, in the Jamabandi. Page 18 I have applied.
Page 23. It is clear. Nolia Dihingya and Zalia Dihingya. Ukto Pattat.
Yes.
So they are the Pattadars.
Yeah.
They may have vanished.
What is there? Your lordship kindly peruse the full.
I have read.
But the person.
Namjari Pabor Karne Abedon Korise. For mutation.
ভূমিলক্ষ্য সহায়কৰ প্ৰতিবেদন মতে উক্ত দাগৰ 1 বিঘা মাটি ধান খেতি কৰি ৰাজহ স্থানীয় কৰ পৰিশোধ কৰি আহিছে যদিও উক্ত পাট্টা ও দাগত আবেদনকাৰীৰ নাম নথিভুক্ত হৈ থকা দেখা নাযায়।
So what had happened to your application for mutation?
অন্য হাতেদি গাঁও প্ৰধানৰ প্ৰতিবেদনৰ পৰা জনা যায় যে উক্ত ব্যক্তি দুজনৰ নামে কোনো ব্যক্তি উক্ত ঠাইত নাই। So
now,
fictitious.
No, cannot.
I am not on that, my lord. I am not.
Let us see your prayer.
To correct to dispose of my application. That my limited prayer.
Where is your application?
Page 18. On the basis of this application, they have inquired the matter. And this
mutation is a service under the Right to Public Services Act. You make an application. Mutation is different. Your prayer.
Your lordship, what comes?
No, Mr. I can understand, Mr. Mutation is for the purpose of collecting revenue.
Collecting.
Right.
Yes.
It may be by way of position under section 53 and 53A, from 50 to 53A of the Assam Land and Revenue Regulation. And your prayer in this petition is correcting the land record, meaning thereby the patta is to be corrected. That is a different matter, sir.
Your lordship kindly.
Otherwise, I can give you right.
For a moment.
Liberty. No, I have understood your case.
But what comes in my way, my lord? Your lordship kindly for a moment, my lord, page 24. What comes in my way, my lord?
Oh, no, Mr. First, let me understand. You are seeking mutation, meaning thereby registration,
yes,
in the parcel of land, or you are seeking correction.
Correction.
In the patta.
Correction, that is
correct. That I am dismissing it. Heard.
Your lordship,
Mr. Patta, no, you have, court has already recorded. By way of giving revenue, we cannot be a title holder. As clear as that. As clear as water.
I am not praying.
No, sir.
For a moment, my lord.
The prayer in paragraph 13.
1 minute, your lordship. Kindly bear with me, my lord. What comes in my way, my lord?
If you want an application for mutation, which does not give you title, but it is permissible for depositing revenue because of your possession, I can give you liberty to file an application for mutation under the Right to Public Services Act. And if it is a patta land, if you want title, that is only by way of adverse possession against this Nalia and Jalia by instituting a civil suit.
Only mutation, that observation will do.
Yes. Then you consider a fresh application as per the Right to Public. Mutation is a service,
Yes. Fact, my lord,
notified service,
except with
heard.
online.
Mr. A.I. Uddin, learned counsel for the petitioner, and Miss Ann Bordeloi, learned standing counsel, Revenue Department. For the respondent number 1, Miss M. Mormon,
2 to 4 M.
learned junior government advocate. For the respondent number 2, 3, 4, and 5. Post of. Para. In continuation, in deference to the order dated 1/4/2026 passed by this court, the petitioner has filed an additional affidavit wherein he has annexed copies of few revenue receipts from which year?
2016, my lord.
2016 onwards.
17 to 26.
17 to, from the during the period paid by the petitioner for the parcel of land during the period from 2017 to 2026. First of. But it is the case of the petitioner that he is in possession of a plot of land measuring 1 bigha covered by dag number 27 and patta number 78, comma, situate at number 1, Sholguri Kisham, page paragraph 2 does it. Chapon Moja. Sepon or Sapon?
Chapon.
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 CHEPON. Chapon. Moja Chapon. Moran Revenue Circle, District, Dibrugarh, Assam. Within bracket, quote unquote, subject plot for land. Post of. It is the further case of the petition that he is in possession of the subject land since 1970. Post of. Para. After making submission, having gone through the materials brought on record by the petitioner, comma, this court is of the view that the requisites for issuance of a notice for the direction sought for in this writ petition, that is, a direction to the respondents to correct the land records in respect of the subject land, are not met. First stop. Para, Mr. Inabuddin, learned counsel for the petitioner, has submitted that the petitioner be granted, petitioner is seeking mutation of the subject land, in view of his long occupation and for depositing the revenue assessed by the revenue authorities for the subject plot, comma, which should not amount to title, right title and interest on the subject plot. First of all, Para, Miss Bordeloi and Miss Bormon have submitted that an application, mutation within bracket registration is a notified service under the Assam Right to Public Services Act, 2012 as amended. And it is open for the petitioner to make such an application in the prescribed format with the deposit of the requisite fees. Full stop. In response, Mr. Inabuddin has submitted that the petitioner is ready and willing to submit an application for mutation of the subject plot under the Right to Public Services Act 2012 as amended, as, according to the petitioner, he has satisfied all the required norms for seeking mutation of the subject lot in his name. Full stop. In view of the above submissions made by the learned counsel for the parties, and having regard to the prayer made in this petition, which is found not entertainable, this petition is disposed of, is dismissed with the liberty to the petitioner to file appropriate application for mutation under the provisions in respect of the subject lot under the provisions of the Assam Right to Public Services Act as expeditiously as possible, preferably within a period of 1 month from today. And if such an application is filed, the competent authority to decide such application shall consider the application on its own merits and thereafter pass appropriate, pass a region order, pass an order, pass a region order as required as per law and on its own merits.
We specify time.
It is there already. It is in the act itself. Within 30 days, everything is there.
My lord, my kindly, instead of dismiss, dispose of.
When I said not entertainable,
instead of dismiss, maybe it may be disposed of.
Closed.
I am obliged.
Timing matter, item 16.
16.
Yeah, please, Your Lordship. You know what I am praying for here in this case, petitioner husband was a LIC agent and he died leaving behind petitioner and their minor son as heirs. So they are praying for renewal commission, that is hereditary commission.
Did you make any application?
Yes, my lord.
When?
My lord, starts from, my lord, page 20.
Heard Mr. J. Sharma, learned counsel for the petitioner. Close stop. The petitioner has stated that the petitioner's husband was an agent under the Respondent Life Insurance Corporation of India, within bracket LICI. And he died. And he expired on 12/12/2017. The petitioner has projected that after the date of the petitioner husband, the petitioner and other dependents are entitled to receive renewal hereditary commission. Full stop. The petitioner stated that seeking renewal hereditary commission, the petitioner submitted a number of applications before the respondent LICI authorities. Full stop. Agreed by non-dispersal of renewal hereditary commission and other benefits. The petitioner has approached this court by the instant petition, issue notice returnable on so and so. The learned counsel for the petitioner shall take steps for service of notice upon the respondents by speed post. For service of notice upon the respondents by speed post within 3 working days from today.
Deeply. 1206. Production list, item 1.
No, please. Impugned order at page 34. This is the removal.
34.
34, Lordship, Annexure 6.
Rahul Das Kalivari Bazar Sribhumi. So, show us the photograph of your that construction.
Kindly turn to
Photo, any
page-
photograph?
No, Lordship. Page
Huh?
17, kindly see, Lordship. Page 17. This is the permission for construct the Pakka house, Lordship. The respondent authority, they have itself, Lordship.
17.
Page 17, Lordship. On 3rd of
Rahul Deka.
2022, they have issued the NOC. Pursuant to this NOC, Lordship, I have
Mr.
constructed.
Doctor,
And I have installed a ice factory where I invested more than 40 lakhs, Lordship, with Uddum under the Uddum DIS.
rightly or wrongly, executive officer.
My lord, proper instruction I'll take, but the petitioner, my lord, has not annexed relevant documents like allotment orders.
Allotment
Because
orders,
But
I
this
have-
order is specifically in his name.
Yes, in this letter, my lord, if it is correct, my lord, it says the NOC for some Pakka house, my
Pakka
lord,
house.
as per his petition.
Pakka house.
He has not annexed that petition, what he asked for.
Kalivari Bazar bill
Yes.
allotted against you. With the allotment.
How he approached, my lord,
Lordship,
what is
paragraph
his
2 kindly
petition,
see.
that is not annexed, my lord. So,
Paragraph,
But as on that it is against this order, first you permit.
for
Then
NOC for
he has changed his position.
And-
Right or wrong, whatever is
and
there.
another angle, my lord. If is correct also, my lord, it says NOC for Pakka house, but his all the bills, my lord, these are not for
This is-
construction, my lord.
this is my expenditure regarding.
Expenditure is-
construction.
No, we will not
running
take into
a-
account. We are not taking into account, but let us by page 17 and page 34.
My lord,
It appears he was allowed some Pakka house.
some Pakka
Whether-
house allowed,
or
but
whether with power or not. That is a
that
different
is
thing.
subject to your.
But as on that privacy, he has a case not to maintain status quo,
Maybe, my lord.
not to take any further action subsequent to the notice. Third, Mr. A. B. T. Hawk, learned counsel for the petitioner, and Mr. S. Doctor, learned standing counsel,
For all the respondents.
Panchayat and Rural Development Department, for all the respondents. First up, the petitioner has stated that he was his father was allotted a bhit, BHIT, within bracket room at Kalivari Bazar under Bhairav Nagar Anchalik Panchayat in the year 1999, and after the demise of his father.
No, father is
Okay.
still now, Lordship.
Okay. And thereafter, Kamada Said bhit was allotted to the petitioner on 12/8/2021 on 30 years leaves, Rostam, on 3/5/2022, comma, the respondent number 5. Five or 4?
Both are the same, my lord.
Respondent number 5. By
Anchalik Panchayat.
no objection certificate, NOC, dated 3/5/2022. Agora 3/5/2022 বাদ দিও। Had allowed the petitioner to construct a Pakka house within the specific allotted bhit area with the approval of the President Ramkrishna Nagar Anchalik Panchayat. Post up. The petitioner Now, in this petition, the petitioner has sealed a notice dated 27/4/2026 issued to him under the hand of the respondent number 4, whereby the petition has been directed to remove the permanent construction from the allotted bit within a period of 7 days from the date of receipt of the notice dated 27/4/2026, and to restore the land to its original condition. Full stop. In the notice, it is indicated that the petitioner has unauthorizedly constructed a permanent structure on his allotted bit. Full stop. Issue notice returnable on so and so. As Mr. Doctor has appeared and accepted, Standing Counsel has appeared and accepted notice on behalf of all the respondents. Issuance of formal notice to the respondents is dispensed with. The learned counsel for the petition shall furnish requisite number of extra copies of the petition along with an annexed to Mr. Doctor within 3 working days from today. Full stop. It transpires that by order dated by the NOC dated 3/4/5/2022, the respondent number 5 had allowed an application of the petitioner for construction of a permanent structure at the allotted bit allotted to the petitioner at Kalibari Bazarville. By the impugned notice dated 27/4/2026, the said permanent structure has been directed to remove and to restore the land or restore the bill area to its original condition within a period of 7 days on the ground that the structure erected by the petitioner at the wheat area is unauthorized. Having regard to the fact that the respondent 5 had earlier granted no objection certificate to the petitioner to construct a permanent structure at the allotted bit on 3/5/2022. It is ordered in the interim that there shall not be any action, aggressive action from the respondents for removal of the permanent structure at the petitioner's allotted bits till the return.
1206. All right. Item number 26 for admission.
You have to cut short the history,
Yes.
What happens if encroachment case number 1 of 2008 and 9?
Page number?
No, page number, your lordship. I'll take your lordship to page 21.
Just a minute. There is an order of mine.
Settlement বিশেষ পোৱা নাই।
Page Annexa 7? Oh, sorry, Annexa E.
Annexa E, my lord, at page 38.
There is an affidavit.
Affidavit is there. What about the in the order?
What is there in the order?
My lord,
I have understood. There is no, there is already an order of mine. So I have recorded that. Just a minute. Who has filed this affidavit?
Number 2. Assistant Commissioner Dorong. my lord.
Assistant Commissioner Dorong. Mr. Sharma. Page 26.
Lordship, I also want to relate that.
Everything started from encroachment case number
Lordship,
1/2008-9.
Lordship.
So litigation took all this time. But encroachment case number has kept registered.
Lordship,
What is the meaning of registration of a case?
Lordship.
Encroachment case for eviction of. And come to page 21. What the additional deputy commissioner directed to the circle officer on 29 June 2009 carry out eviction operation.
Lordship.
So how can he say, turn around and say that there is? So natural result is, and court has declared them
I think
opportunity.
it's a wrong into that. No outright order of any eviction to be carried out was passed by the honorable court.
It
It's
is
a wrong-
he.
Lordship. Lordship, I agree, Lordship.
Huh?
I do not want to argue on that. The
Okay,
affidavit
I'll
is
pass
there.
it, detail order tomorrow.
Lordship, Lordship, Lordship.
At this stage, particularly difficult.
My lord.
Okay. Yes, what do you say?
I should not argue.
Are you
Lordship.
defending this? Otherwise, you have to make submission this way or that way.
No, Lordship, I cannot. I cannot.
If you defend, I'll record. And if you oppose, I'll record.
If I defend them, Lordship, in that case, I have to give up my this profession.
Okay, I heard Mr. S. Kotokil, counsel for the petitioner. Yes, Ms. Bodola, you want to defend this? Division bench judgment, you oppose? Okay, and board was standing as a revenue. And it's from additional senior government advocate. So, let it be on Thursday, listing will be difficult.
Lordship.
Okay, we'll list the case on Thursday, and then never will be made to dispose of the writ petition.
7. Item 27.
Yes.
Lordship, here the petitioner's land has been taken over and utilized by the, my lord, the irrigation department, but without any land acquisition proceeding and without payment of any compensation. My lord. That is the main issue involved in this case. my
They have all of them have filed affidavit.
lord. Reading is completed. my lord.
Okay, let us put it on Tuesday. Because we have to go through
Yes.
their affidavits.
Take some time.
Okay. M. Dotto petitioner. N. Upadhyay, standing counsel irrigation department. Miss M. Bormon, Lieutenant Junior Government Advocate, Assam, for us. State respondents have submitted that the exchange of pleading is complete. Release the case again on Tuesday.
Right. Item 28.
Obligation.
Item 28, my lord, appears to be bench 3 matter.
Is it?
Is challenge the appointment of the private respondent.
Okay. There is no representation on behalf of the petitioner today on call. Mr. S. Dr. Land Standing Council, Panchayat and Rural Development Department, and Ms. M. Bormal, Land Junior Government Advocate, appearing for a state respondent, has submitted that the subject matter of the petition pertains to bench 3. So, in view of the above submission, raised to examine whether the petition pertains to bench 3 or otherwise, and therefore release the case before the appropriate bench after a week on a date to be fixed by the notice.
Item 29.
This is also bench 3 matter.
Bench 3.
Yes.
Mr. S.K. Singh, petitioner, S. Borua, learned
Central Government Council.
Central Government Council for the respondents. Item
Item 30.
Yes, Ms. Atia.
Lordship, we have been directed to file our affidavit. Affidavit is ready, but some miscommunication, Lordship, it was not sent.
So what time?
By next week, Lordship. we will
Okay.
file.
Or Ms. A. Shatia, learned counsel for the petitioner. Petitioners. Mr. H. Sharma, learned additional senior government advocate for the respondent number 1.
1, 6, and 7.
1, 6, and 7. And Miss N. Bordello, standing counsel Revenue Department for the respondent number 3. Respondent number 4 and 5 to the on call. Mr. Sharma has submitted that.
The next week we will file this.
Sought for listing of the case after 2 weeks in order to file the counter affidavit on behalf of the respondent number 1, 6, and 7 in the meantime. Full stop. Praise the Lord, list the case on
1 6.
for filing of counter affidavit by on behalf of the respondent number 1, 6, and 7.
Much obliged.
Item 32.
I heard Mr. K. Ahmed, learned counsel for the petitioner. Revenue and Bordello.
Lordship, we have received the instruction whereby it is stated that the mutation was cancelled because of the land is found to be agricultural class 2 land.
Any order?
That I think
In this application, what is sought for?
mutation.
Muted the name of the petitioner.
Lordship.
An appeal.
File, my lord.
Huh?
Appeal is there, my lord. Second appeal is also there, my lord.
Provision is there.
I already filed, my lord.
Filed.
Yes.
Then why this?
Lordship.
Then, my lord, it is rejected, my lord. Closed,
Which
my
one?
lord. At page 30, my lord.
Huh?
Appeal is auto closed. Page 30, annexure 7, my lord.
Mutation after deed registration. Appeal, take your appeal. This is first appeal.
My lord.
First appeal.
My lord.
Now there is a second appeal.
Second appeal, page 31, my lord.
No, nowadays it is a commission. There is a commission, is it not? The chief minister inaugurated with much fanfare. Yes. Yes.
Date of particular date on enforcement and funding.
No. There is provision for second appeal under Right to Public Services Act. a commission has already been placed with
I have to check.
yes, yes. Yes.
Lordship may fix it any other date.
আছে নেকি চাওঁ এটা যে কাগজ আছিল না second appeal like no it is thereafter it has come in the newspaper.
As per my lord, Assam Right to Public Services Act 2012, my lord.
Commission, no. Thereafter,
Section 8, it is said.
say with if I'm not wrong, Ranjit Shekhar Musari as the chairman and two other big names as the members. Chief Minister of State Government has inaugurated it. I have seen, because I have seen it with interest that second appeal would now go to that commission. Huh? Before whom?
The applicant agreed by any order of the appellate authority may make a second appeal within 60 days from the date of receipt of the order of the appellate authority in the appeal before the commission.
Commission. Now commission has been named and commission members, chairmen are all appointed. And there was a statement by the Chief Minister, now appeal would be entertained by this. I would ভুল হয়েছে তো আরো নতুন অ্যামেন্ডমেন্ট হয়েছে হয়ে পেলে এবার সব বহুত বেলেগ হয়ে গেল
2019.
Please, you are the revenue department. Bring out on record, get the information. What is the commission? The Mr. K.U. Ahmed and for the petitioner and Bodoloi revenue for one. H. Sharma, direction. Additional senior government advocate for the respondent number 2 and 3. Post of Paramis Bodoloi shall obtain instruction as to whether any second appellate authority commission, they will dispose of third appeal. First appeal, second appeal, third appeal. Commission will dispose of third appeal. Second appeal will be disposed of by opening instruction, who is the second appellate authority. For the appeal, second appeal, preferred by the petitioner in this case. If Commissioner Secretary is the second appellate authority, you will direct him. Right? Release the case on Monday. Then we will dispose of.
Obliged.
1105.
That is the third appellate, Mr. Please get the instruction.
May I?
And I have seen all India officers, 2 or 3, are to be made chief commissioner and commissioner. And I have read the statement in newspaper that commission has now been functioning. Every appeal will be disposed of by the commissioners. Now I have understood, I thought that it is second appeal, now it is third appeal. That is for the very reason that, so that these officers can dispose of the appeal.
My lord, it may be 14, my lord. 1-4, my lord, 14th of May.
4.
14 Thursday.
Thursday, 12?
My lord,
Not 12, 13.
8, my lord.
So, only the instruction.
My lord. But I am not able with that, is my lord.
Ask your
Okay. Obliged.
11. Ask somebody to be present. If I find that this petition can be disposed of with a direction to the second appellate authority, I'll dispose of, or otherwise I'll not.
My lord, obliged.
Okay, Mr. Learned Counsel for the petition, furnish an extra copy of the read petition along with annexure to Ms. Bordolo by tomorrow.
My lord, already filed, my lord.
Yeah.
33.
Yes, Mr. Sharma.
My lord, in this case, I have submitted an application, online application for settlement of land, my lord. The actional land measuring 1 kotha 5 lesser situated at Posim Boragaon. And thereafter,
Where is the application?
my lord, page 15.
Yes, 15.
Bosundra.
16/12/2024.
Yes, ma'am.
Then what happened?
And thereafter, my lord, page 18, last remarks rejected by the circle officer, applied for land is vulnerable to landslide, applied for land is a declared hill. It is a status of the online application. But the adjacent plot of land is a Medipatta land, my lord.
Yeah, it will satisfy a region order.
It is not a region order.
Lordship, that's because it's a vulnerable landslide area, Lordship.
Only it has been reflected in the portal, my lord.
And that.
I think as per the act, he is required to pass a region order, whether it fulfills falls in the category of declared hill.
Yes.
Thereafter, I have
But he is
submitted,
asking for a settlement, Lordship, under the Bosundra.
and thereafter, I
Cannot be given.
Why you are not preferring an appeal?
thereafter, I have submitted 2 representation page
No,
21.
representation will not do thereafter. It is a right to public service.
Let them obtain, so on the speaking order has not been passed, my lord. Only such remarks is there.
This is the order. It was applied for land is vulnerable to landslide. Applied for land is a declared hill.
I have been told my learned friend that under Bosundra, there is no scope of appeal.
Okay.
They have to apply, reapply.
Let them file affidavit, my lord.
The same thing will come if your Lordship file an affidavit, Lordship. This is specifically mentioned, cannot be given as because landslide area.
Okay, what is the order passed in the earlier one? Regarding Bosundra 30,
Lordship
item number?
has for the
Produce the Bosundra claim.
Item number 24. Okay, let us put it along with item number 24 on the same date. N. Sharma, petitioner, N. Bordolo, standing counsel revenue,
2 and 3.
H. Sharma, additional senior government advocate for the respondent 2 and 3. See the item number 24. Same date. Same date. 11/5.
Yes, my lord.
Item 34.
My lord. The opponent is to file it.
File affidavit.
I'm seeking 1 week's time, my lord, to file it.
You are for which department?
Forest Department.
Forest. And anybody has filed affidavit?
No one.
Okay.
The private respondent also has not filed.
Private.
You are for private respondent. You need to file any affidavit. How much time you need? 3. Okay, 3. Anybody else? Who are the main respondent? Forest? Okay. Mr. A. Bhattacharya, Learned Counsel for the petitioners. H. Sharma, Learned Additional Senior Government Advocate for the respondent number 1, 3, and 4. Ms. N. Bordeloi, Learned Standing Counsel, Revenue Department for the respondent number 2. Mr. I. Bhattakur, Learned Standing Counsel, Forest Department for the respondent number 6. And Mr. S.K. Poddar, Learned Counsel for the respondent number 7. Post of both Mr. Bhattakur and Mr. Poddar have sought for and granted 3 weeks time to file counter affidavit on behalf of the respondent number 6 and the respondent number 7 respectively. List the case on
3rd June, 0306.
Item 35.
Yes,
Regarding my lord.
claim for compensation.
Compensation has been received, my lord. Now, as provided under the law, my lord, they are entitled for, my lord, 2.5% interest as provided in the law. And my lord, a covered case is, my lord, I have enclosed here, exactly similar, my lord. Judgment I have enclosed here. So your lordship can pass.
Yes, whether
That is,
covered.
my lord, page 29.
I am not examining. Covered.
Covered.
For interest part, can be my lord, but the instruction is still awaited, my lord, no instruction has been received. As lordship-
Compensation they have received as per the act, my lord, they are entitled for compensation.
Okay.
Detailed order is given.
Okay, you examine, then I will decide.
Position.
Thursday, then?
Huh?
Thursday
Thursday, yes.
or next Tuesday. Tuesday, on next Tuesday. On next Tuesday.
Okay.
Heard Miss Anne Soike, Learned Counsel for the petitioner. And Anne Bordeloi, Learned Standing Counsel, Revenue Department for the respondent number 1, 3. Miss M. Mormon, Learned Junior Government Advocate for the respondent number 4 and 5. None has appeared for the respondent number 3 to the on-call. Post of Ms. Soike has submitted that the case of the petitioner is similar to the petitioner in the petition WBC number 7196/2013,
yes,
which has been disposed of by judgment and order dated 4/10/2023 within bracket Annexa 9. Post of Ms. Bordeloi and Ms. Vermont have sought listing of the case on next Tuesday in order to examine whether the case of the petition is similar to the petitioner in WPC number 7196/2013. List the case on Tuesday.
1205.
Obliged.
Item 36.
May I please, lordship?
And last short time earlier,
If instruction is still awaited.
awaited.
Patient may be sure.
2 plots of land have been acquired, even notice was not issued. Okay. Hard miss,
Armidhi.
Armedi Learned Counsel for the petitioner. Water resource, Mr. D. Keso, Learned Counsel on behalf of Mr. N. Upadhyay or R. M. Das, Learned Standing Counsel. Water Resources Department for the respondent number 1, 2, 3. And Miss M. Mormon, Junior Government Advocate for the respondent number 4 and 5. Post of. The respondents are granted further 3 weeks time to obtain the necessary instruction and to file their respective counter affidavits. As short for. Post of is the case. In the month of May, the respondents will ensure that the counter affidavits are filed before the next date of listing.
Obliged.
37.
June. Yes. Petitioner residents of Hatfala, Mulagram, Odima, Gonda, Andhra. Did you lodge any FIR?
No, my lord, complaint was given to the PNRD department, commissioner, my lord. And a complaint was also filed to the, my lord, your lordship will find.
Yes, Mr.
Instruction is awaited, my lord.
Okay.
But lordship, page number 20, he filed a complaint to Director of Vigilance and Anti-Corruption also.
My lord.
Since notice has been issued, so you file your
Yes.
counter affidavit.
My lord.
And Mr. A.H. Emma Choudhury, learned counselor, petitioner. Petitioners. As doctor. 1, 2.
1, 12, 4.
4. M. Burman, huh? My Hindi by resignation. 4. Mr. Doctor, Standing Office of Panchat and Rural Development Department have prayed for and is granted 2 weeks' time to obtain the necessary instruction to file the counterfeit on behalf of the respondent number 1, 2, and 4. This is the case up to 3 weeks on a date to the expert office. Okay.
Item 40.
My lord, in this case, my lord, petitioner's bank account was breached in connection with a criminal case, my lord. My lord, first of all, my lord, a bank account cannot be seized, my lord. It can be seized as per provision of CRPC, my lord.
Service is there or not?
Service complete, my lord. Both respondent appeared, my lord.
Where is that?
Standing counsel UBI appeared on last occasion, my lord. And another thing, my lord, is that, my lord, in that account, my lord, he received the policy benefit of an insurance policy, my lord. And because of
Any anything from the IO for seizure of the bank account?
No, my lord.
Hmm?
My lord, so far seizure of bank,
Your this thing, Union Bank of India.
yes, my lord. My lord,
Can you trans-
kindly have a look, page 35, my lord. Your lordship will find on 10/1/2026,
Huh?
2,35, my lord, page 35.
2 lakh?
2,50,000 was credited in his bank account on 10/1/2069. The maturity of insurance policy, my lord. And so far legal part
2,50,000.
50,000, my lord. He received from his insurance policies, my lord. Insurance policy was matured, my lord. So far, freezing of bank account is concerned, my lord. Police cannot freeze, my lord. It is settled, my lord. Only court can, under section 107 BNSS, my lord. Court can.
No. Police can
seize, my lord. Seize, but cannot.
Don't try to play with the court. That police cannot seize.
No, police cannot seize the
It is
document, my lord.
It is a property, right? Under 300A, right? Upon the Nyogi. The procedure is prescribed. Police can seek, but question is about information to the court.
Yes, my lord.
Right?
Under
Don't
section
say that the police cannot seize. Yes, madam, file your affidavit. Why the reasons are there? Let us see.
In fact, my lord, annexure 5, there is a magistral order also, my lord.
The annexure 5.
Annexure 5.
Page.
Page, my lord, 25.
Which part is the account of
Yeah.
25?
25 in this report.
25.
Is the order sheet from the magistrate records. Here the so many schemes and so many applications of the
Hmm.
This is the document relating to bank account, my lord. Document.
Substantiate your policy. What policy you have?
Insurance policy, my lord.
Huh?
Insurance policy.
Insurance policy. You received it from whom?
From Kotak Mahindra Bank.
Why don't you make them a party?
They are not party name.
Huh?
They are not party.
If you were so, because you were an accused in number of cases.
What number of cases? One case.
4 number at least I have found out. Siphoning of huge amount of money. So why don't you make him a party? Or let us let the Union Bank file also an affidavit. We will decide. And that is the instruction by respondent 4.
Yes, SP Hussain.
File that.
Lord.
Heard Mr. A.H.M.R. Choudhury, learned counsel for the petitioner, and Ms. M. Bormal, learned junior government advocate for the respondent 1 and 4. The learned counsel for the learned standing counsel, Union Bank of India, for the respondent number 2 and 3 is found absent today on post of. Ms. Bormal has submitted that she has received instructions from the
Yes, from my lord, Superintendent of Police Hujai.
received
But he is
instruction
not a party here.
from the superintendent of police Hujai. And she would bring the same instruction in the form of affidavit. To the respondent number 4.
I will try.
Post up. The respondent Union Bank of India shall also file its counter affidavit on or before the next date of listing. List the case after 3 weeks, did you?
My lord, another point, my lord. This bank account was freezed on 26 September 2024, my lord. And this amount was credited in his bank account only on 10/1/2026, my lord.
Yes.
Much earlier, my lord. It was freezed in 2024, my lord. And this
2024.
24, my lord.
Ah.
And policy was matured in 2026 and it was credited in 2026, my lord. Kindly page 37, my lord.
Let him file the affidavit if it does not indicate an application for freezing of the bank account and permission from the or notice to the court, then we may allow you. But there is no indication of an application.
No.
So let them file, because otherwise you are involved in courts. Let them file, thereafter we'll decide. There is a case on so and so.
3rd June, 0306. For orders, item 42.
Office note.
As per observation made by the registry, my lord, I dated 30th of April.
Heard, Mr.
M.
M. Soikel and counsel for the petitioner, M. Bormon, Learned Junior Government Advocate Assam, for the response number 1 and 2. 1 and 2, full stop. Para, as per order dated 23/4/2026 of the Lawajima Court, service of notice on the response number 3 and 4 is complete, full stop. As the service of notice upon all the respondents is complete, comma, list the case on so and so date in the admission column.
25th May, 2505. Item number 43.
May I please, your lordship?
Yes.
My lordship, here in this case, we have filed affidavit, lordship, kindly go through the affidavit.
I did not go through. What is your name?
A.
Your
Alim
name?
Sheikh, lordship.
Huh?
A. Alim Sheikh.
A. Alim Sheikh, Learned Counsel for the petition. And Mr. Dotto, you are for petitioners, huh? Mr. Dotto, Learned Standing Counsel, Panchayat and Rural Development Department for the response number 1.
Only one.
1.
Next one.
Miss AB and AB and Nogam and B. Castro, Learned Standing Counsel, Assam State. Huh? R. Dubey, he has become senior counsel. Huh? So R. Dubey is not senior counsel. Huh?
Not now.
Not now. Okay, Learned Standing Counsel, R. Dubey, Learned Standing Counsel. ASAC for the response number 2. Miss M. Bormon, Learned
Three and
Government Advocate for the response number 3.
3 and 4.
4. And Mr.
R. Karim for 6.
R. Karim for the response number 6. First of para. The petition and counsel for the petition submitted that and if a compliance affidavit as regards service of notice by Dusty has been filed. First of has been filed. First of let the case be placed before the Lawajima Court for report as regards service of notice upon the respondent number 5, 7, 8 and 9. And place the case thereafter on so and so.
Lordship, respondent number 5 and respondent number 6 also appeared, lordship. 7, 8, lordship, denied to accept the Dusty as well as.
No, I don't examine this affidavit. Let Lawajima Court examine. I am not going into that clerical things.
Yes.
2505.
Lordship, can it be as 23 or 20? 23?
23 বন্ধ হয়ে গেছে।
23
Next.
can.
29.
20. I did 23 or 24. Thank you.
No, according to the convenience of the court.
Holidays.
Holidays.
25 and 29.
25th.
Lordship, kindly after.
Item 44.
June.
Okay.
May please, your lordship. Dusty service.
Yes, you are Mr.
K. Rega, lordship.
A. Rekha,
Yes, sir.
petitioner. Yeah, also Dusty.
It's completed, your lordship. Service is completed.
I don't examine. And Mr.
Correspondent number 1, S. Kakoti.
S. Kakuti, Learned Standing Counsel, Central Government Council. For the response number 1, full stop. The petitioner, Learned Counsel for the petitioner submitted that an affidavit has been filed as regards service of notice upon the response number 2 by way of Dusty, full stop. Same order. Same order, like the previous one.
2505.
Obliged.
Item 45.
H.M.R. Chaudhary, learned counsel for the petition. Who is for the respondents? S. Musari, learned counsel on behalf of Mr. S. Dr. Learned Senior Counsel for the response number? Response number? 2. Anybody, Central Government Council?
May I please your lordship? Your lordship, I am appearing on behalf of K. Vishwakarma. He is a newly engaged counsel for LIC and we are representing 3 to 6 LIC.
Your name, please?
Miss Arnott.
Arna. And what is your senior's name?
K. Vishwakarma.
K. Vishwakarma. Okay, Miss Arnott, learned counsel. On behalf of Mr. K. Vishwakarma, learned standing counsel. LICI has submitted that she has instruction to enter appearance on behalf of the respondent number 3, 4, 5, and 6. Close down. As the respondent number 1 is represented by the Deputy Solicitor General of India, the service of notice upon all the respondents is treated to be complete. You have filed Ukalanama?
We will be filing.
Okay, and we'll be filing an Ukalanama to that effect within a week from today. Also, Para, release the case. It will accordingly release the case accordingly after a week in the admission column. Give it the case also.
There is another prayer that this annexure 2 and 5 is completely not clear for us to understand.
Okay.
We pray that.
Mr. Chaudhary, learned counsel for the petitioner shall furnish a copy of the petition, two copies of the petition with legible copies of the annexer to the standing counsel LICI within 3 working days from today.
My lord, only one prayer, my lord. So far, annexure 2 is concerned, my lord, I have fair copy. And so far, annexure 5 is concerned, entire dispute is involved in this annexure, my lord. It is originally eligible, my lord. My lord, annexure 5, my lord. That is the entire case, my lord. Depend on annexure 5, my lord.
If eligible, then why I will question the registry why you have admitted.
No, my lord. I have specific paragraph, my lord. My lord, case is that, my lord. My lord, kindly see.
Give thereafter decide. Give a copy. Give 2 copies. Type copy, whatever.
Type is also not possible, my lord. The entire case is involved.
Then I am dismissing it for registry admitting this petition.
No, my lord. Case is that, my lord. Petitioner purchased a policy, my lord. When petitioner died, my lord. Policy holder died, my lord. Then she was asked to provide the document, my lord. And she is furnished a medical.
What is this Annexure 5 document?
Annexure is a medical certificate, my lord. Medical certificate.
Before whom it was submitted?
Before it was before LIC, my lord. LIC and petitioner.
It was acknowledged.
Yes, my lord.
Huh?
Yes, my lord.
Okay, give without a legible copy of Annexure 5. We'll decide. Because if it is, if they say that they have received, then we'll decide.
Obliged, your lordship.
Very good.